this would be, oh, we're being recorded. So that is the one document that, before you get into a lot of discussion, you must present to the consumer. And that happens on the buy side or the list side. Hey, Marshall, it's a pleasure. Thanks for coming in today. I'm happy to talk about 125 Main Street. I just want to let you know the state of Massachusetts wants me to explain to you agency and your rights in the Commonwealth and who I am at this very moment in our discussion. Okay, so that's when you would whip up this form and you would go over it with them, because the state of Massachusetts wants the consumer to know, is Marshall talking to me as someone that is going to eventually hopefully represent me, my best interests as a consumer? Is Marshall here selling that house for the seller and he represents that seller's best interest? Or is Marshall here as a what's called facilitator, someone who is a non-agent? And what does that mean, right? The state of Massachusetts requires you to disclose that upfront. And I'll tell you, unfortunately, in our industry, the majority of agents don't do that. Okay, they don't want to present it. They think they're going to blow the opportunity. They just want to show the property. They just want to see if they can get the person comfortable with them, and then maybe they'll do it down the road. How do I know this? I'm a heavy listing agent, okay? And when I receive offers, 5, 10, 15 offers at a time coming in, I get a copy of the agency form. Now, most of the time, it's filled out the day they're writing the offer. Now, how many agents out there you think are so good that they're showing one piece of property and writing an offer on it, and the form is being filled out at that time? Not many, okay? So it is what it is. It's supposed to be, I have agency forms that have been filled out a year ago, and we're still working with the people. And when I send offers, and I can say, look, I've worked with these people so long, you could see it on the agency form how long I've been working with them. Now, when it comes to writing offers, that's a whole different discussion point. There's some strategy around that. You might have a form signed, an agency form signed when you first meet the person, but you don't feel comfortable sending it to the listing agent because you don't want to let them know how long you've been working with the person. That's just something that could be considered, and you might fill out a new one with your client at that time. But I don't know that as the listing agent, what's coming at me. Is everyone clear with me on what I'm saying with this?
So every time you write up an offer, you don't need to have a move.
Correct. There has been confusion on that, right? Like, am I supposed to have one for every unique property that I show?
That's what
that's what you've been doing? Right. So the Commonwealth hasn't really, given guidance saying you must fill out a new form for every property you're showing your buyer. That's not what they've said. It's really just at the first personal meeting to discuss a specific property. And then going forward, you've created what's called an agency. All right. Once you've created the agency relationship and you disclosed who you are in that working process, I think, that's satisfactory that you have the one form and you're showing your client 20 different properties. Okay. Now, could someone argue a different way around that? Sure. Someone could say, well, no, it says at the first meeting to discuss a specific property, and every property you show is a specific property. So therefore it should be a new form every time. But I don't think the state intended that, right? So just do it once when you're first, meeting the buyer or you're first getting hired as a buyer agent. Okay. So
thought about doing it again.
Of course, yeah, because we never taught it that way.
Yeah.
It's just not the way it is.
As somebody who has a listing, what would it matter in terms of if I've been working with my client for, say, a year looking for, as opposed to if I just started working with them 3 months ago? Like, does it make a difference in terms of?
Everything makes a difference, right? So when you send me a listing, an offer package, I can tell. I could say, well, they might be, I might perceive it as you might have a more committed buyer. Your buyer might have been, on the hunt for longer and is really serious about buying this home, versus his buyer's got it filled out on the same day. And I'm like, have they seen any homes yet? Are they committed to buying the home? I don't even, are they just jumping? Are they going to get cold feet? So, a lot of that can play up into a benefit or a negative. There's no black and white 100% on things, but, and of course, in different market times, this strategy and this mindset can change, right? So the market mindset. Hello, Shelley.
Hi, yes,
Hi.
I just wanted to, Ashley said I can just jump in here. She did, yeah, it's there in writing. So anyway, I just wanted to point out, because I was talking to my script partner this morning, who's been around a little while longer than I have, and they did revise the disclosure as of September 20th of this past year. And that first paragraph is what they changed, that if you don't meet in person, but you must provide it electronically prior to entering into a contract. I just wanted to point that out in case anyone didn't know that.
So you see, yes, you're right. Actually, this form, Ashley, are you there? Ashley. Yeah, because this form I'm looking at.
Yeah, what
thank
can I
you, Shelley.
do?
Yeah, so we're looking at, so the form you gave me was a 2017 form on the agency form, and Shelley is correct that the agency form just changed. All right, like maybe a few weeks ago, Shelley, right? Like in the early
September
December, I think.
20th, I was
September.
notified by the MAR. Yeah.
Right, right. So could you kindly kind of bop into like DocuSign or dot loop, because they probably have the updated form there, I would imagine.
Yeah.
And then
Yeah, let me grab Kate. Hold on one second.
yeah, get me a
Let
copy
me
of
take
that.
care of it.
Thank you, Shelley, for bringing that up. I actually hadn't reviewed this just yet to see that. I would have noticed that too. So thank you, Shelley. So what Shelley is referencing to, and what we'll get into when we get the updated form to us today, is how the form is to be presented and when it's to be presented. And things. There's some other minor modifications on it. And Shelley, yeah, I actually did read that form. I think MLS actually put that up in the you know, when you log into MLS, there's like a notes section in the middle. I think they actually added it there as well. So thank you. Okay, so let's jump in. We're gonna go, we'll skip agency for the moment until we get the updated form, which is that very first form. And we're gonna talk about the exclusive buyer agency agreement, right? Exclusive buyer agency agreement. This is the longest form in the whole process today, the one that we're really gonna dig into and read. And this is a class where we kind of have people participate, and you know, Zach might read a paragraph, Amy might read a paragraph, Marshall, et cetera, and I may read it. I'll be reading as well. As we go through it, I'll be stopping at certain points and going into more detail around stuff. And of course, you guys, if you have questions on what we're reading, we can stop and discuss it at that time too. Okay. Now, once again, you're not just handing this to someone and saying, sign this. This is typically brought out after you've had a buyer agency consultation. We've had a consultation. Amy, come on in. We're going to talk about your needs and expectations, go over the process, give you a little education on the marketplace, see where your opportunities and weaknesses are, you know, based upon your unique situation. And if everything seems to sound good, you know, we'll put some paperwork in place that allows us to be your representative in this process. Does that sound good? Right. So you're just going to say something like that. Then you're going to have them into the office and you're going to do your buyer consultation. The buyer consultation, you know, Chris might do it different than Zach, might do it different than Marshall, might do it different than me. Okay. And that's where you're going to go over needs and expectations. And like I just said, so market insight and, you know, potential plan. And, you know, you're deciding, do you want to work with these people? And do they want to work with you? Right. And at the end of the day, you know, everything sounds good. Chrissy, let's put some information, you know, paperwork in place that allows us to go to work for you today and provide you with all the things that we're going to describe in this broker's services and duties, right? So let's jump in. I'll start reading first. Exclusive buyer agency agreement with consent to designated agency and consent to dual agency, right? We'll go over those paragraphs when they come up. This exclusive buyer agency agreement is made between, right? And blank. So the first blank is going to be the buyer. And this is where you're going to put the buyer's name in. Mr. and Mrs. Ron and Deb Carpenito. Al Bodwin, you know, whoever's name, you know, whoever the buyer is. It could be like I just closed a deal for a company. So the buyer was Larsh Boston North, the name of the company. They're buying it in the company's name. And there was a, you know, authorized representative of the company, that kind of thing. So you're working with an investor, maybe they have an LLC set up. You're putting in, you know, the Alpine Village Realty Trust LLC is the buyer, right? Who is the buyer? Okay. Of course, you're always going to indicate the name of the person who's the authorized representative as well. So Alpine Village Realty Trust, Kim Horstman as trustee, something like that, or Kim Horstman as authorized representative. The person you might be working with that's authorized to sign these contracts, right? Good question that comes up sometimes is if you're signing contracts for a corporation and there's a person signing on behalf of the corporation, do you need some type of authorization letter from the corporation that authorizes this person to sign on behalf of the corporation? That's a great question, right? And I would say I wouldn't sweat that too much, right? I would just maybe ask them, you know, if it's a big company or something, I might say, oh, you know, my office may require some authorization letter for you to make this decision on behalf of your company. Can you get that for us at some point? You know, and they'll say, yeah, sure, no problem. You know, in the event if it's like, you know, I am Ron Carpenito and I own the Ron Carpenito Trust, and it's the Ron Carpenito Trust is buying the property. I'm Ron Carpenito. I might provide a copy of the trust documents to the brokerage firm to prove that I am the trustee and that I have the authority to sign documents on behalf of the trust. These things can come up, right? But at the moment of getting hired and getting the sign, don't sweat it too much. Just say, hey, oh, you know, your company, we might need further documentation that gives you authorization. And that'll be a, you know, Kate kind of question. She might want that on the records based upon what she's seeing for documentation when she goes through your loops, right? All right. And broker. So who's the broker? Who do you think you'd write in here, Chris?
Me,
You're the broker? Oh, are you the broker here?
no.
You're not the broker, right? You're a salesperson, right? Everybody here pretty much has a salesperson's
So
license.
Susan's name was in there?
Well,
Keller Williams.
technically she's the broker, right? But what we write in is Keller Williams Realty Success.
Oh, that's
Keller-
right. That is what I do.
That's what you do.
Sorry.
There you go. Because we're
I have a
not,
little sample at home.
right, you
that you
probably,
taught
that I
me.
taught you from years ago,
Yes,
right?
exactly.
So we are not the broker, right? We are salespeople at this office. Even if you have a broker's license, you are still affiliating with this office as a salesperson. You might have a broker's license, but it's falling under Keller Williams Realty, right? So you're gonna put in Keller Williams Realty Success, because that's the full name of our company, right? Right, our brokerage. That's what I'd like you to write in there. I mean, if you're writing Keller Williams Realty Andover, that would be descriptive enough to, but Keller Williams Realty Success, that's the name of our brokerage firm. So just put the right name in, right? In consideration of the mutual promises set forth below, buyer and broker agree as follows. 1, exclusive buyer agency. Hey, the buyer grants the broker the exclusive right to locate or procure real property acceptable for purchase and lease by the buyer. Buyer, you're giving me the right to represent you. I'm the representative in the purchase here. Okay? Buyer further agrees to refer all potential acceptable real property to the broker during the term of the agreement and agrees to notify all real estate agents who communicate with the buyer of the broker's exclusive agency relationship with the buyer. So, Mr. Buyer, how do I mute it?
Jesus,
Little microphone.
what?
Let's see, people, so I'm a little bit, I have not taught on Zoom myself, to a group of this many people, right? So sounds like someone, Ashley, did you just mute everybody? I think you probably did, because I can't hear.
No,
Okay,
I think
it
we're.
looks like people might have self muted. Is there a button for me to mute people if I needed to? like a
Yes, if
all-
you go over to, do you have the participants up? You can click participants at the bottom of your screen and you can see everybody.
Yes,
When you can see their little microphones,
yes.
that's what you click on.
Oh, I have to click each
Just
individual microphone?
Like everyone is muted right now.
Correct. But if there was like 50 people here, there should be like a master mute button, right? Mute all?
Yeah,
Okay. All right,
if
well,
you go, it's at the bottom.
I do not see it, but that's okay. We don't need it right now. Okay,
Okay.
because everyone seems to be muted. Okay, so here we go. Let's continue. Any questions on what I just read? About, no, it's pretty self-explanatory, right? Hey, buyer, you're out there. You're gonna notify other agents that I'm your agent. I'm representing you. So, this kind of plays into the open house thing when they go to open houses, that the listing agent knows that they're represented by you, right? The final decision whether or not to purchase a property is acceptable for purchase shall be solely within the discretion of the buyer. Obviously, the buyer is going to make the decision, right? Term of the agency. How long is this going to be from? The term of the agency shall be from blank to blank. Now, commonly, we put it 6 months as a common, time frame. You are in a much longer and harder market to be a buyer agent, so you may want to consider a full year. Now, you can use time in many different ways. You might be in front of a buyer that maybe you don't want to work with for so long. You want to try them on, Chrissy.
Mhm.
So maybe you're gonna put a month here, 1 month, right? We'll give it a month, Marshall, see how it goes, and we can extend this. And it naturally extends by action. But if it's not working out, we can, 1 month will be a trial. I always go with 6 months because if you're meeting with me, you pretty much were referred to me by somebody, because I work by referral, right? So I pretty much know I'm gonna work with these people. I get a good vibe. Very rarely do I get a vibe like, oh my God, I can't work with this person, right? It has happened. Sometimes I'll, if I get that vibe, I might do 3 months, right? And you give it 3 months and go from there. But time can be used to, in many different ways for you. You can sign this for a day, sign this for a week, right? Our office requires that we have Amy, our office requires that we have an understanding of expectations and needs on both sides of the equation. I understand that you might be a little nervous about this, so why don't we just put this in for 2 weeks? If this happens, we'll do it for 2 weeks and we'll take it from there. No harm, no foul. I'll work with you for a couple of weeks, show you what I can do, and we'll continue from there. So it doesn't have to be like a 6 month locked in contract, right? And there are some other things that we can write into the additional terms as well that we'll get to in a bit.
How are you handling with your buyers
Yes.
this whole inventory situation?
That is a great question, but not focused on this form.
All right.
But we will talk about that later.
All right,
Okay, so thank you, Ashley. Ashley's bringing in the updated form.
thanks.
I imagine you might send it to the at-home audience as well. Okay, good. Thank you, Ashley. Okay. So we talked about terminated. Term of agency shall be from blank to blank unless extended verbally or in writing or terminated by completion of the purpose or by agreement. Okay. So what's that mean? Well, if the time is up, unless you got, hey, Chrissy, our time's up. Do you want to keep working together? Sure. Yeah, verbally is great. That's what it allows for. I don't like verbally. My company, my team, we always get an extension of contract, right? So I would do that. Writing or terminated by completion of the purpose or by agreement. So again, if you, verbally or in writing or terminated by the completion of the purpose. So if you sold the property, you've got them to buy a property, this contract is over. Like your buyer agency agreement ends once you've completed the contract. You've done what you've agreed to do, right? Or by agreement. So there could be some type of other agreement to extend. Brokers, services, and duties. All right, Chris, why don't you jump in and start reading this for me a little bit? We'll break it up.
Broker agrees to use reasonable efforts to locate real property acceptable to buyer and to assist buyer to negotiate terms and conditions of a contract acceptable to buyer for the acquisition of the real property, the contract. The contract may consist of an accepted offer, purchase and sale agreement, option, deed, exchange agreement, lease, or similar instrument.
Stop. Okay, so this exclusive agreement is allowing you to do a multitude of things, right? Not just a sale, but also getting an option on a contract, option for a property, right? Negotiating a P&S agreement, meaning we don't have an offer form, we're going right to P&S agreement. A lease, you could use this to help someone lease a property, okay? So this form is multi-usage for multi different things. Now, I will tell you, 99% of the time, you're getting this signed to help someone buy a home, not a lease. Most people aren't getting this signed to go out and lease a property with somebody, right? Could be used for that, doesn't need to be, right? We have other forms for things like that. If you literally do want to work with renters or people who want to lease property, we have like exclusive representation by facilitation. We have different types of representation forms, but 99% of the time, this is what you're going to use, okay? To help someone buy a property. Continue.
Broker agrees to assist in locating properties, arrange showings, analyze financing alternatives, give advice concerning real estate practices and procedures, assist in negotiations, arrange inspections requested by buyer, and coordinate activities throughout the process.
Now, everybody, that is exactly what you want to highlight, that section, right? That is what you are going to promise and do and deliver to the people who are hiring you as their agent and their representative. That's a lot of stuff, right?
Yeah.
When a lot of people might think that what we do doesn't amount to much or we don't do a lot, but you're going to be doing all of this stuff, whether you know it or not. You are, okay? You're working 3, 4, 5 times as hard as a buyer agent right now, okay? You don't want a buyer going off and buying without you, okay? So having something like this, although not bulletproof, sets expectations. I'm your agent, you're my client, right? I'm going to work my ass off for you. Right? You work harder for someone would you work harder for someone that is committed to working with you? Right. Would you scope out properties knowing that you're guaranteed to get paid? Of course you would, right? I mean, I love Scouts Honor and I don't need a contract. I work just as hard for everyone. Great. You work harder for people that have hired you. Absolutely. Because now the expectation is there. They're committed to you. They're not going away. They're not going to buy from listing agent directly. They're not going to go and just, another agent called me up and I'm working with them. Could it happen? Yes. We don't live in a black and white world. We live in gray. Things happen. Yes. This gives you a leg to stand on. Doesn't mean you're going to pursue them for legal action or things like that, but it's a leg to stand on if you needed to, if you wanted to, if the broker wanted to, because remember the contracts are between the brokerage firm and the client, not you and the client, right? But all good points to make. But again, what you just read are really the levels of service and what you're going to be doing that you should internalize this. This is what I'm doing. Here's all the activities I'm going to be doing and what I've described in our consultation. that you can rely upon me for, right? Continue.
Buyer agrees that such services do not constitute a guarantee or warranty concerning any real property.
Perfect. Continue.
Buyer agrees the broker has not been retained as an attorney, inspector, home inspector, pest and termite inspector, septic inspector, surveyor, or to determine the condition of the real property, and has not been retained to provide legal advice,
Mhm.
to provide an opinion concerning lawfulness of
Mhm.
current or anticipated uses,
Mhm.
to perform a title search, or to act as a mortgage broker.
This is huge. Okay. This is, again, we talk about setting expectations and what you can be liable for and what is your job as a real estate professional. It's lining it out. It's laying it out right here. Here's what I can do for you. Here's what I'm not doing for you, right? Crystal clear, no confusion, no lawsuits after the fact. No, Chris didn't tell me that I couldn't run a daycare out of this house. Well, it says right here, you can't rely upon me for that. I'm not a municipality. You know, I don't know everything that this property could be used for. It's spelling it out to the client and yourself to keep everybody knowing what's going on. Okay, continue.
Buyer agrees that broker shall have no duty to disclose any matter or condition outside the boundaries of the real property
Mhm.
being considered for purchase, including but not limited to present conditions and anticipated changes in the neighborhood where the property is located.
Stop. So what that means is, hey, Mr. Buyer, I can't know everything about everything going on in the neighborhood, in the community, that, a subdivision is going to be built, right at the end of this dead end that you just moved on, and that you're going to have 3 years of noise and aggravation from the construction crews and things like that. This actually happened to me. Okay. I love telling stories because I've got enough at this point in time. And a great client of mine, liked privacy, liked quiet, liked nature. And so she wanted to buy this property. It was for sale by owner by the contractor himself who was building it, right? She went to an open house without me, whatever. And that's okay, they can do that. But, she calls me up all excited about it. And, I go to meet her, we talk about it. She's like, and he said it's all conservation land behind the house. I'm like, really? Okay, are you sure about that? Well, it's owned by Richardson's Dairy Farm and they're not going to do anything with it, he said. I said, okay. I said, you might want to research that. I don't know, if I can't give you advice on that. You might want to go to the town and talk about that. It says right here that I'm not going to be able to give you definitive answers on anticipated use and changes in the neighborhood and things like that. She relied upon what he said. Sure enough, less than a year later, Richardson's sells the land and it's being developed. And now all her Facebook pictures are my poor trees are being cut down in the back and, looking at the construction. And I've had several calls with her about it. And she's talked to the attorneys and things and, because she's very upset with that statement he made. Right. So people do hold you to statements and things like that. So you definitely want to have clear, this is what this is for, providing clear expectations of what you are doing and not doing. Now, do people memorize this and remember this? No, not all the time. Again, this is to give the market center and yourself something to potentially rely upon if a lawsuit were to happen. If, a buyer calls you up and says, XYZ, you didn't do this, you didn't do that. Geez, I'm sorry, Amy. I don't know where you thought I would be doing that. I apologize. You feel this way, based on what we do, in the paperwork we put together, I explained to you that I don't do that. And a lot of times then the problem goes away. So pull it out there, read it, and go, yeah, Amy wasn't responsible for that. And I signed this, and then the problem goes away, right? So these things can be helpful for you. All right, let's continue.
Okay. What's that? Broker recommends.
Right, broker recommends.
That an attorney and other professionals, losing my space,
That's okay.
may be hired for such services as buyer deems appropriate, and that buyer personally investigate particular matters which may be of importance, including but not limited to neighborhood composition, the level of crime, and presence of sex offenders.
All right, stop.
Mhm.
Never, ever, ever, never, ever, ever, never tell a buyer, I checked out the sex offender registry, you're all set. I went down to the police department, it's a safe neighborhood. Don't do that, okay? So many agents in our industry, what do they want to be? They want to be helpful. They want to feel like they're earning their fee. They want to feel like they're protecting their client, okay? Tell me in the real estate licensing class where it taught you how to protect somebody. Does your license say protect someone? No, you are not to protect people. Your job is to provide them with whatever it is we've agreed to provide them with, which is typically, what is the risk and opportunities here? What is the real estate all about? Is it the right decision for what I want to buy? Is it the right property for me to buy, right? Does this mean you can't help them seek answers out? No, of course not. Chrissy, you know, I can't tell you what's going on crime-wise and sex offender-wise or whatever you want to, however you want to say it, Chris, but I recommend you go to the police department and check things out. You've got 2 little kids, it might be a good idea to check things out or whatever. You know, I'd be happy to escort you down to the police department and look at the police logs. Let's look it over. Would you like a meeting with the school superintendent? Let's try to set that up. I'd happy to be sitting in that meeting with you, things like that, right? You can guide them, you know, hey, you've just put a house under agreement. Now we're going to have a home inspection, which is, you know, the home and any aspect thereof. But I also recommend to all my clients that you check it out with the police department, make a phone call, go down there, tell them, put it in an email, send them that message to them. Do not do it for them. The minute you do it for them, now you're taking responsibility. And I'm not saying that you shouldn't do things and help people. We want to help people. Isn't it fair to say that I'm protecting you in a way, it's such a way that, hey, I've protected you by telling you to go to the police department and check the sex offender registry out, right? Right, that's me helping to protect you. But again, your license does not say protect them. Agency is what? Obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Reasonable care is that it pertains to the license that you hold. The license that you hold does not say to protect people, okay? People are adults, they make their own decisions, you get it? You can help guide them, they make the decisions, okay? And especially when it comes to crime and sex offenders. What I think is a high level of crime might be nothing for somebody else. What you think is a high level of crime might be nothing to me. So when we do it all the time. I'm guilty too. I've done it. I mean, come on, we're human. This is a safe area. How many times have you said that showing a property? Oh, it's a safe area, don't worry. You know, safe to who? It might be safe to me, but the consumer on the other end might have had a very bad situation with crime. Might have been assaulted, house broken into, someone murdered that you don't know, right? And then to them, any level of crime could be not safe, right? And so you cannot make decisions based upon your personal feelings as to what is safe, okay? So don't say it's a safe neighborhood. Even with schools, people say, is it a good school system? I want my kid to go to I want to buy a home in a good school system. The answer is, what does a good school system look like to you? Tell me, what would you feel a good school system is? Let's go over here to the mass.gov website, which actually has all the ratings of schools, and you can sort it by what is important to you. Good school system to me might be low student to teacher ratio with high money spent per pupil. Good school to you might be high level of dollars spent on athletics. Good school to you might be high level of diversity, might be high level of high school students that go on to college, might be, I don't know, something else. So what is good to you is not good to me, vice versa. You don't make that assumption for the person that it's good. Okay, I'm getting a little bit off track. Let's go back on track. Okay, I'll continue. Broker agrees to preserve confidential information of the buyer, making disclosure of confidential information solely to the extent necessary to establish buyer's financial qualifications, i.e. the pre-qualification letter, or showing some confidential information to the seller and the seller's agent that you are qualified financially to make a purchase. That's the kind of information, pre-approval, right? Broker represents that the broker is duly licensed as a real estate broker in Massachusetts, obvious. The buyers advise that the sellers or sellers' representatives are not required to treat the existence, terms, or conditions of an offer as confidential unless a confidentiality agreement has been made with the seller before submission of an offer. This is the line that all the hands start going up. Wait a minute, I thought all offers had to be kept confidential. Do you believe that? Where did you learn that? Who taught you that? That offers must be kept confidential. Tomorrow's class, we're going to go over the listing agreement, okay? And in that listing agreement that we use, which is a standard form, it does provide some level of what can be shared with other brokers and what can't. But furthermore, there are other documents that if given permission, listing agents absolutely have the right to disclose offer information to other brokers in the interest of getting their client, the seller, a better offer. So we are disclosing to the buyer, do not assume that your offer will be kept confidential. Okay? It's not, should never be, unless what? Unless a letter of confidentiality has been signed by the seller, agreeing to keep this offer confidential. Okay?
So I can tell another agent?
You can tell another agent details about an offer if you have permission from the seller to do it. Okay?
Rules and dates, so on and stuff like that.
Offer details, correct. All right, we, in our office, have a form that you get signed by the seller, to get an authorization to do that. If you don't have authorization to do it, then your listing agreement, which we're going to review tomorrow, will specify what offer details you are allowed to disclose. Okay, we're going to go over that tomorrow. So come back for that class. The buyer understands that broker represents other buyers. This is the huge line and is mentioned multiple times in this process, because guess what? You guys are not going to work with one client at a time. I hope not, because you're not going to feed your family if you are. You need multiple clients, right? The buyer understands that the broker represents other buyers and agrees that it will not constitute a breach of duty for the buyer's agent to introduce another prospective buyer to a property in which the buyer may be interested, or to assist another buyer with a purchase. I remember one time I had 3 clients all looking for the same type of property. Property pops up, all 3 want to see it. Okay. I set up 3 appointments, 30 minutes apart. And literally I show it, I drive around the neighborhood, I come back, I show it again. This will happen to you. Okay. You need to be able to sell a home, more clients than just one client. Okay. But you will never disclose to a buyer that you're working with another buyer. That gets really hairy. You've got to keep that separate. I have written offers on the same property with multiple clients. Okay. So, I have confidentiality, right? So I can't tell you, Amy, what other offers might be. I'm not telling you I have another buyer writing an offer, but I'm trying to help you to write your best possible offer. It gets a little bit dicey, but you have to, but this again, you're explaining. Imagine in today's world, who brags on Facebook when they sell a home? Everybody. Now, when you have 5 clients looking in the same area in a cutthroat real estate market we're in, and you put up, so happy, my clients closed on 125 Main Street, but you have 3 other clients that might have been interested in 125 Main Street. Could that cause those clients to get upset? Hey, Amy, we wrote an offer with you on that too, and we didn't get it, but your other client did? That's going to cause a problem or a question mark. Right here, you're explaining to them, I have a family to feed. I can't just work with only one client. I hope you understand that it's not a breach of my duties to you to work with other clients, because that's what we do. We help people buy and sell homes. And, I'll treat you like you're my only client, but you're not my only client. You need to let them know that.
Maybe you don't post that sale.
Maybe, good. Chrissy said, maybe you don't post that sale. I think that's a good idea. That's a good idea. Okay. The broker shall maintain confidentiality of material information of each buyer. What is the material information? Motives, terms, and values. Motives, terms, and values. MTV. When we talk about confidentiality in our fiduciary duty, what is that? It's motives, terms, and values. That's what you're keeping confidential. Motives. Why are we doing this? Oh man, I got to get my mother moved in with me because she's fallen 3 times a week now, and we've got to get keeping her safe. That's my motives. That's why I'm doing this, right? Terms. Well, I am willing to do I'm willing to pay over asking price, but only by so much. I'm willing to put down this amount of money. I'm willing to, give on that. Terms, what I'm willing to accept. And values. What's important to me in this process? Speed's important, communication's important. What do I value about this whole process? These kind of things need to be kept confidential. Okay. MTV. And we will keep those matters confidential. Should either party, now this is where we get a little bit legalese. Should either party file a claim of violation of General Law, Chapter 93A? I'm sure we're all familiar with what Chapter 93A is, the Consumer Protection Act, right? The prevailing party, including any agent of the broker, will be entitled to recover the reasonable attorney's fees and costs, but no fees and costs shall be recovered in the event that a tender or settlement was made in advance of suit and rejected, and the court or arbitrator determined that the rejected tender was reasonable in relationship to the injury actually suffered. What does that jibber jabber mean? Marshall, all this means is if something actually went wrong, and nothing will, believe me, we'll work this out. whatever part, if you bring a claim against us and you prevail, then, we might be responsible for your attorney's fees and such and things like that. And of course, if we prevail, then you'll be responsible for our attorney fees. And of course, if we were to offer you a settlement of some sort before going to court and you rejected it, but the courts thought that it was reasonable, then, no attorney's fees will be owed. Okay, because we tried to settle this before court. That's basically what that means. A tender is you've made an offer to them prior to going to court. Okay. Now, do I sit across from somebody and go through line by line like I'm going with you? No. This would take 8 hours to get hired. But what you're going to have to do is you're going to have to internalize this and somehow summarize it that you're comfortable speaking out. Hey, Amy, this section talks about our duties to you, and I'm going to do these 7 things. And, let's review a little bit here. No, I'm not going to be able to check on the sex offender registry. I'm going to help you with that stuff. I can't, you're going to have to summarize this so you can make them feel comfortable moving forward. Okay. So you're going to have to learn this stuff. Now, the buyer's duties. Buyer's duties. The buyer agrees to work exclusively with the broker during the term of the agreement. The buyer agrees to conduct all negotiations with the knowledge and assistance of the broker. Hey, Mr. Buyer, when you're at an open house, don't start discussing, what you're willing to offer with the listing agent. Don't start, engaging with them. Their job is to gather as much information about you to share with their client to aid their client's negotiating ability. Okay. The buyer agrees to cooperate with the broker by providing relevant personal and financial information and to cooperate in scheduling and attending showings. Amy, if I set up a showing, you're going to be there? Please don't leave me hanging. I'm not going to show homes unless you come in. So you're going to cooperate with going on the showings, right? The buyer agrees to advise the broker of any interest in the purchase or lease of real property about which the buyer was introduced, was previously advised by another person. So Amy, thanks for coming to visit me, hiring me today. I'm just curious, have you seen any of the property, or has anyone told you about any homes that are of interest of you that I should start following up on immediately? You're going to advise me of that. The buyer shall provide any lender's letter of pre-approval or pre-qualification to the broker within 7 days of receipt. If you're on top of your game, these buyers are using your lender. Okay. One of the best things I've ever done was connect with 1 or 2 good lenders, right? And form those relationships that I'm getting my people pre-qualified by my people before I even meet with them. Okay. I don't want to meet with anyone who's not qualified to buy a home. I don't. It's a waste of time. I'm not looking to meet with people that have bad credit scores that can't get a mortgage. I mean, what is the purpose here? We don't go to the mall without our credit card, is what I tell people. We don't go shopping without the credit card. The credit card is the pre-qual, right? It's in your best interest, Zach, to get pre-qual. Why? Because simply, you're going to find out what you can afford. You're going to find out if you even get a mortgage, and it'll save you 3 hours with me that you wouldn't want to waste if you couldn't buy a home. Okay? So it's in your best interest to do. I'm going to have my guy, Jason, call you. He'll take great care of you. Soup to nuts, take you through a proper detailed qualification. All of my buyers have closed with him, and he works for a highly respected lender in our area that all the other listing agents are aware of and know. So it's going to help you when you write an offer. He's also situated in our office, so we have some local, control and ability to hold them accountable. And they pick up my call at 8 o'clock at night on a Sunday, basically, is why it's important. So you want to leverage my relationships. Doesn't mean they can't work with anyone else. Of course they can. I'm just, as a buyer agent, you have the legal authority to put people in front of your clients because they're your client and you're their representative. So that's what buyer agency allows you to do. One of the things it allows you to do.
It's interesting in the contract, it refers to us as the broker.
Right, because this contract is between the brokerage firm and the buyer,
Right,
and you are the representative
right,
of the broker.
right.
Mhm.
But it uses the term broker everywhere,
Right, because the contract is signed between the broker.
so I have nothing to do with it. I'm just the representative.
You're technically, the brokerage firm is responsible for your actions.
Right.
Right. That's why you're affiliated with a brokerage firm. So that's the insurance here, the E&O insurance and all that stuff is under the broker firm. Right.
Right.
Your name is going to be mentioned on the backside in a minute, though. Okay, here we go. 7 days. Buyer agrees not to attend any open houses with advance notice and approval of the broker, and agrees to advise the listing brokers at each open house of the buyer agency's relationship with the broker. Hey, so Amy, here's how I work. Amy, I want you to go to open houses, and you don't have to clear it with me. Obviously, I'm fine with that. But what I usually do, Sunday morning, I wake up, I get my coffee ready, and all my clients tend to email me the homes they're going to go visit on open house. Then what I do is I reach out to the listing agent, let them know you're coming, And then I'll send you any additional documentation like seller's disclosures, lead paints, property information that might be helpful for you to know before you go to the open house, right? So would you do that for me, Amy? Would you just send me an email on Sunday morning on ones you're looking to go, the homes you're looking to go check out? Great. And I literally do that on Sunday morning. I'm there with my coffee. Emails are coming in and I'm reaching out to listing agents. Now, what does that do? One, I know where they're going. Two, I'm sending them more information. I'm providing more service, right? Three, I am calling the listing agent. I'm not calling the listing agent because listing agents are bombarded these days. You know, I'm gently sending them an email through MLS, right? Saying, hey, Chris, it's Ron Carpenito. My client, Amy, is coming to your open house today. She's a wonderful person. We've been on the hunt for a while. She's super excited. You know, this could be the one. I'll follow up with you with any feedback or questions later. Please take great care of her. Now, 60% of the time, I'll get an email back. 50 to 60% of the time, I'll get an email back. Gee, thanks so much. I'll keep an eye out for her. Appreciate the heads up. And then, I mean, I imagine when Amy goes, if it's not so super busy and she, oh, Ron called me. What am I doing? I'm building a relationship, right? So that if I do send an offer over, that's an extra little nudge in my corner, like Ron's on top of his game. Ron just, you know, that's what you're supposed to do. You're supposed to alert the other agents that your client's coming. That's customary. I just did a deal. The MLS co-broke was 2%, right? After the offer got submitted, without even asking, the listing agent texts me. I can show you the text. I really appreciate your offer. You are definitely on top of your game. I'm upping the co-broke to 2.5%. I didn't do anything that I wouldn't normally do professionally, okay? Act professional, okay? And people will there are agents that will recognize that. Remember, sometimes the MLS co-broke is set low, right? And it can be improved, okay? We're gonna talk about fee soon because it didn't matter to me that he did that because I have an agreement to get paid by my buyer, which is this, okay? Which we're gonna go over next, all right? But it was helpful because that saved my buyer money now, right? Because she owes me a fee at closing, a balance of the fee, right? He just was willing to offer more now, so that saved her money. So she was excited about that when she heard that. All right, let's continue. Where did I leave off? Oh yeah, buyer represents that the buyer is not subject to an earlier agency agreement with any other broker or any protection period. Now, it makes me really irate when you come into contact with a consumer and they can't even remember their agent's name, okay? So if you think that they're gonna remember that they signed a document like this, right? 6 months ago when they first met some guy that's showing them property, you know, you would hope that they would. You would hope that they know that they're under a buyer agency agreement, but you're at least asking the question. Don't be surprised if they did sign something and they didn't remember that they signed something. Because a lot of times a lot of agents aren't doing, you know, a high level job. A lot of agents, you know, listen, you're going to be in this business a long time. You're going to see a lot of things. You're going to see people like me, professional, suit and tie guy, you know, literally, you know, treat it like a company, a business. And I'm like, you know, and you're going to find plenty of people who are like part-time. I'm looking to make it, you know, do 5 or 6 deals a year. You know, it's not my bread and butter. And they're just loosey-goosey. They get someone on a web search on Zillow and they get a phone call every once in a while to go show a property. Those people exist. There's plenty of them. Their clients barely even know their names. So to think that those people are getting things signed or they got things that don't, not everyone is as polished and professional as you all are here at Keller Williams, right? So sadly, but that's the way it is. But you still ask the question. You want to make sure that they're not subject to another broker agreement. Because if they are, they could be in jeopardy. You go out and buy a home with them. Now they owe you a fee or you're collecting co-broke fee, but they have a contract with somebody else. That broker could say, hey, wait a minute. My agent's been working with you for 5 months. I've written 5 offers with you. And you go out and check up with Ron and write an offer. You owe us a fee. We saw that you closed on that. This stuff happens. I've never had it happen to me. I'm not aware of any cases of it happening, but it could happen if someone is signed up to another contract. So that's why you ask them. The buyer understands that this agreement does not relieve the buyer of the duty to exercise due diligence for the buyer's own protection, including the duty to investigate any information of importance to the buyer. The buyer further understands and agrees that the broker may show other prospective buyers properties in which the buyer may be interested. That's twice it's mentioned. Think it's important? They put it in twice. It's important. I'm telling you, it's cutthroat on the buy side. When I say cutthroat, I don't mean it like, you know, in a bad way. I just mean it's very tense. It's tense on the buy side. Buyers are like, you know, they're taking it on the chin. It's tough. And they can be aggravating, you know, I never wrote more offers than I wrote this year. I wrote more offers this year. And, you know, I was probably 75% list side, 25% buy side this year, only for the fact that even I am having a hard time getting offers accepted. Even my own nephew, I've written 5 offers with my own nephew, and he's like, whatever I need to do, Uncle Ron, let me know. And like, so he's like the ultimate client, like whatever I tell him to do, he will do and recommend. And even doing it, we're not winning. And then I'm seeing the closings happening, and they're like even more than I'm like, yeah, cash. And I'm saying to my wife, who's his nephew, he's her nephew too. I'm like, it's weird because I'm telling my own nephew what it feels challenging, It's weird. Okay, so broker's commission. So this is where you're gonna talk about how you get paid and how much you charge, things like that. So the buyer agrees to pay the broker a retainer. Buyer shall pay broker a retainer in the amount of X dollars upon signing the agreement as compensation for professional counseling, consultation, and research. Such retainer is non-refundable and shall or shall not be credited against a success fee, which is in the next paragraph. So what is this? Well, you can use this form for many different reasons. Exactly what it just said. You might be getting paid not to help them buy a home. You might be getting paid to help them research a subdivision. You might be getting paid by a developer saying, I want to know this property here. Can you tell me if I put 5 homes on it, what they might sell for, do a little legwork on that. That's one thing. I don't know if you really use this form for that, but, counseling and consultation is, you can be paid a fee for that, right? A lot of agents use this section for like an administrative fee, right? So some of the bigger teams have like a $395 transaction fee or administration fee that will be paid up front to get them onboarded with the team to start working, right? I would suspect that in today's age where buyer agents are working 10 times as hard, right, that they might be starting to charge an upfront fee to compensate for some of their time and effort, okay? Because guys, you're gonna work your ass off. If you get something accepted on the first offer, bravo, right? Count your blessings, right? Very challenging. And it doesn't look like it's gonna change anytime soon. Okay, it's gonna be another tough 2022 for the buyer agents, okay? So do I put anything in here? Personally, I have never put anything in, right? I know that there are some teams in our office that have done this. They've put retainers in here, right? What's great about it is, everything's negotiable, right? So, I mean, if you're talking, something could come up with a buyer client saying, listen, I only want you to accept what the MLS co-broke is, but I will pay you something up front, I can't even envision too much about what a buyer would say about this because most buyers aren't really aware of this kind of stuff until you bring it up. But if you're working with some sophisticated buyers and investors and things like that, there might be a case for retainers and upfront money. You might get a whiff that someone's not serious about buying, and you might say, listen, I know you want to go explore with me, but I only get paid typically when something closes. So if you really want to spend a year looking at property, I'm happy to do it, but I'm going to need to charge you some money up front to cover my costs. That could be a reason. You've got someone who's got bad credit, but they want to get out there. They want to go see property. They want to utilize your MLS system. They want to utilize your ability to talk to you. And, you're an advisor, real estate advisor. You might want to charge them up front. And you could say, well, Amy, I'm going to charge you, $2,500 up front, for 6 months of services that I'll be happy to provide. And if you do buy something, I will credit it towards our success fee, right? You could do that.
Terms, right?
Huh?
You put that in the terms.
Correct. Right. Well, I would check that box off. It shall be credited against success fees if I wanted to, or shall not. Now let's talk about the success fee. So the parties agree that compensation equal to 3% shall be due broker upon successful completion of the agreement, or in the event that within, and I put 60 days, some agents will put 180 days, some agents will put a full year following the term of the agreement. Buyer or any person acting for the buyer purchases, leases, or otherwise acquires an interest in the real property after becoming aware of the availability of the real property or receiving information about the real property during said term. So what does that mean? Quite simply, it says, hey, when we have a success, I am owed a fee of 3%, right? If our contract expires and for the protectionary period of 60 days beyond, you go and buy a property that I have introduced you to, I'm pretty much going to be brought back in as your realtor. It's kind of how I explain it, right? Our fee is owed because I'm the one who brought that to your attention. Now, again, guys, in real life, are you going to enforce that if it ever happens? It's not up to you. It's up to the broker, okay? And the key here would be you'd probably have a dialogue with our broker at the time and explain your situation as to why you want to be compensated and go after them, or let it go. Don't worry about it, you know, that kind of thing. Again, you're working 10 times as hard as a buyer agent. You work 6 months with someone, you write 10 offers and you've shown 40 properties, and you know, the contract expires and they go back and buy something that you introduce, you might really feel like, hey, you know, you're trying to screw me here. You know, I want to enforce this. You might pitch your case to Susan, our broker, and she's the one really who'll make the decisions on whether we're going to enforce the contract, because the contract's between the broker and the buyer, not you and the buyer. Okay. All right. Let's continue. The parties agree the broker shall first seek compensation, if any, offered by the listing agent or otherwise from the transaction. So where do we see the compensation offered by the listing agent? In the MLS. So the offer of compensation from the listing agent, i.e. the seller through the listing agent, is the MLS co-broker. So that's the first place you look to see about compensation. If full compensation of your fee is obtained, that amount will be credited to the amount of the success fee. If such fee cannot be obtained in whole or in part from the transaction, the buyer agrees to pay the broker the success fee due at the time set for closing. So quite simply, I charge the customary 3% buyer agency fee. Been doing it for 17 years. Probably the highest commissioned agent in this office. When you actually run the numbers and you see who earns the highest percentage commission, my name should pop up at top right around that 3% number. And I've had no problem with it. Okay. 2% from the co-broke, buyer owes me 1% of closing in the closing costs, right? How does it work? Quite simply, Amy, we can ask for closing cost credit from the seller towards our fees, which would basically be financing your fees. We can increase the sale price and get a closing cost credit that way to increase our fees. Or you can pay, you know, out of pocket at closing in total, you know, for our fees.
You never had pushback.
Zero pushback. Again, why? And see, why does everyone think you're gonna have, why do you think you're gonna have pushback?
I guess because I don't know.
You don't know why. You're just
Accept-
programmed to say
accept-
pushback.
Yeah,
Right.
a lot of times people believe that the seller just pays the fee and that's it.
And then it's free. And that buyer agency is free.
Yeah.
Yeah, well, like the
It's
seller
not
will
free.
pay whatever portion the buyer agent.
You'll
deserves.
accept. So let me ask you a question. Let's follow that chain down. Right now, in this kind of climate we're in, what do you normally see where you work for buyer agency fee? What do you normally see? You're seeing 2%, right? What if it was 1%? Would you work for that? Would you quit the business for that? No. What if it was 0? You wouldn't do it, right? So you have a bottom. You charge a fee, and that fee is 2%. Okay? Because if it's less than 2%, are you going to do it? No. Now, can you not show a property if the fee is less than 2% or 0 or $1 or $500? Can you not show the property? You have to show the property, right? Right now in Drake, there is a subdivision where there is no buyer agency co-broke fee. The houses are on for $650 to $750, and the listing agent is doing everything off MLS. If that's the right property for your client, do you have to go show it? Yeah. How are you going to get paid? In a market where there is, you know, I don't even need to pay a buyer agent fee. I will get offers on the home. Let's just talk real. I would never say that to my listing client because I think it's wrong. I think we should share some of our commission with the buyer. You guys are working hard. But do you think if I put a property on with no commission, I would get offers? I would get offers, right? Now, the tables will turn when the market shifts, and you will see those buyer agency co-brokes going up to 3% again and 2.5%. But right now you're in a land where, you know, there's pressure on the buyer agency co-broke fee. Now, I was taught 17 years ago, never rely on a listing agent for your fee. Okay, never. You're getting hired to do a job. This person should be responsible for your fee. Responsible doesn't mean they're always going to pay every piece of it. And you certainly could say, hey, this happened quickly. I know it's 3%. They're offering 2. I'm going to cut that to 2.5. You can come down. You can negotiate if you wanted to, right? But don't ever put in per MLS. Don't ever put in, you know, whatever I can get from the other side. What if there isn't anything from the other side? What if they want to see a for sale by owner and there's no co-broke? You have to show the property. You have to try to negotiate a deal, right? And so your client needs to know that they need to owe you a fee for your services, okay?
I once got 7 offers on a property I had listed,
Yeah,
and one of the offers in that additional terms
Yeah.
on the offer
right.
said seller's agent will pay, I was offering 2, will pay 2.5.
Sure. So what's wrong with that? Well, as long as it's authorized by the buyer to be in the offer, which it was, I
Yeah,
imagine.
which I'm sure it was because it was
And,
signed.
and you, as a professional, presented it to your client without
Yeah.
emotion and without any type of angst,
Right.
as this net offer would be this dollar amount. What do you care?
So it's coming out of the seller ultimately.
It's, that is irrelevant to this
Yeah, I guess
discussion,
you're
right?
You're right.
It's
yeah,
irrelevant.
yeah,
It's a net offer, right?
got it,
So it's,
yes.
how many times you write an offer and you want 10,000 back for a new roof? You want 8,000 back for closing costs.
Same thing.
Your buyer agency fee is another closing cost.
Got it.
right?
okay,
That's all it is.
Okay.
Okay.
Oh,
So, you know, when you present on the listing side, hey, I have an offer here for 300,000, they want 8,000 back, it's a 292 offer. Is that enough to make us move, Mr. Seller? No, you need more money. Okay, let's counter. 305 with 8 back. Hey, does your client really need that $8,000 back? Yeah, they really do need it back for their closing costs. Great. So we're going to work that into the sale price. Okay. Okay. You know, again, put a number in here that works for you. At least put 2% in there. Put something in there. Okay. 3% is where you should be working at. Okay. And then you can always negotiate if you choose to lower.
My New Year's
Okay.
resolution.
Yeah. Give yourself a
3%.
raise, 33% raise
That's right.
this year, right? You could sell 1/3 less properties by putting a 3% in there and make the same money. Okay.
Mhm.
And you're working 10 times as hard. I mean, you're working harder now. Harder, much harder. Much harder. I've been doing this my entire life, even when there was 500 homes to go by, right? Because at that point, there was an analysis paralysis and buyers couldn't make a decision. There's too many homes to buy. Let's go look at the next 5 tomorrow. Let's go with the next 10. Oh, it's going to be cheaper next week. You were working much harder then too. Buyer agents work hard. Okay. Earn your fee. And we can talk about a lot of dialogues around that if you do get pushback, right? One that comes to mind is, hey, just Amy, you say, well, you know, what do you mean you charge a fee? And you say, well, Amy, what do you do for work? Oh, you're a programmer. Great. Would you work for 6 months on a program for your boss without knowing what you were going to earn in the end? Well, no, of course not. Neither would I. Right. You mean I have to pay this? Well, you're responsible for it, Amy. But the good news is, do you have insurance, like health insurance, Amy? You do, right? Sometimes you have a copay on a procedure and sometimes it's covered 100%. Same thing here. Every home we go look at will have some type of a compensation towards our fee. Some is going to be 3%, some is going to be 2.5%, some going to be 2%, some might actually be even less, and some may be 0. And we'll need to figure that out. We'll work it in the office somehow to make it work for you, and you'll make the decision whether all the circumstances around that property make sense for you to purchase it or not. Okay, you'll talk around and be like, okay, fine, and you move forward. Right? I want you to have the opportunity to earn a full fee. Okay. And then you can decide later on if you want to nix it and just accept the co-broke or say, good news, you know, I'm discounting your fee. You know, I had a woman this year, worked my ass off with her, and then she decided to buy affordable housing, right? Because she qualifies for affordable housing. The co-broke was $500. I'm not working for $500. She's in for a 3% buyer agency agreement. Okay. I cut that by 15% to 2.5%, right? Think about the language, right? From 3 to 2.5 is not a 0.5%. It's 15%. I gave her a 15% discount. Okay. When you go from 3 to 2, you're giving them a 33% discount. You know, you want to, if you had a job, would you give your boss a 33% discount? No, of course not. Why would you do this with your clients, right? So that's it on that. Any questions on that? On getting hired for a fee? Okay. If obtained, such amount of agreement, we'll talk about that. If such fee cannot be attained in whole or in part from the transaction, the buyer agrees to pay broker the success fee due time set for closing.
You're muted. Ron, you're muted.
How about now? Can you hear me now, Shelley?
Got it.
Excellent. Okay. All fee disputes, claims, or controversies arising out of or related to this agreement shall, upon demand of either party, be submitted for binding arbitration to the local association board of realtors, or in the event the association board declines to hear the matter, to the American Arbiter Association, or upon mutual agreement, to another dispute resolution service. The realtor arbitration proceedings shall be conducted by a panel of 3 arbiters, according to the then current rules of the Association Board of Realtors, or if before the AAA, by a single arbiter, according to the consumer arbitration rules, or if not applicable, to the commercial arbitration rules of the AAA. And all proceedings will be conducted in a location in Massachusetts chosen by the arbiter. Reasonable attorney fees and costs shall be awarded to the generally prevailing party in the arbitration. Do I read all that to my client? Probably not. All it does is spell out how we're going to resolve a dispute. Hey, Marshall, this paragraph talks about how, if we do have a dispute on fees or disagreement, that we just kind of agree to go to arbitration. This defines how the arbitration will occur, where it will occur in the process. Okay. Next paragraph, right? You don't have to read it line by line. All right. Consent to designated agency. So before I read this, does everyone understand what designated agency is? Anybody at home? You're all good? Okay. Designated agency, quite simply, is how our office operates. We're a designated agency office where the broker of record, Susan Roquard, is basically, like a magic wand appointing Ron Carpenito as a representative for the client in this office. And Ron Carpenito and only Ron Carpenito represents the client. Susan Roquard, the broker of record, is always in a agency relationship with the client, right? As well as me, because she is the responsible party. Okay. Consent to designated agency. A designated agent is a real estate licensee who has been appointed by a broker or salesperson to represent a buyer as a designated buyer's agent, or to represent a seller as a designated seller's agent. When a buyer or a seller consent to designated agency, only the designated agent represent the buyer or seller. Any other agents affiliated with the broker may represent another party to the transaction, and by consenting to designated agency, the buyer or the seller permit those agents to represent another party. All this means is when Chris hires me as her designated agent in the office, Susan Roquard is appointing me Chris's agent. However, she also understands and agrees that the home that she might want to buy might be listed by Amy in our office as a designated agent for the seller, and that Amy represents the seller only, and that Ron represents Chris only, the buyer. Okay. Individuals who are designated agents owe fiduciary duties to their respective clients. You are further advised that the designated buyer's agent will represent the buyer and will owe the buyer the duties of loyalty, full disclosure, confidentiality, account for funds, accounting, and reasonable care and obedience to lawful instructions. Remembered as what? Old car, right? All other licensees affiliated with the appointing broker, Susan, will not represent the buyer, nor will they owe the other duties specified in the paragraph, in paragraph A, to that buyer, and may potentially represent the seller. And C, if designated agents affiliated with the same broker representing the seller and buyer in a transaction, the appointing broker, Susan, shall be a dual agent, okay, and neutral as to any conflicting interests of the seller and the buyer, but will continue to owe the seller and the buyer the duties of confidentiality of material information and to account for funds, remembered as CA. What does that mean? Quite simply, I'll break it down. I'm representing Chris here as the buyer agent. Amy is representing Marshall as the seller's agent. Susan Roquard, our broker, is now in dual agency because she represents both clients. Her fiduciary duties are dropped down to confidentiality and accounting and disclosure, right? What did it say? CA, CA, confidentiality and accounting of funds. Okay. Yeah. I'm getting tongue tied now. Yes. Okay. By signing this agreement, buyer consents to designated agency. If this designated agency occurs in a transaction, a notice of designated agency will be given. This one sentence has provided the most confusion over the past 4 years, but we are now pretty crystal clear on what needs to happen. And what needs to happen is if I am the buyer agent representing, say, Chris, and Amy is the seller's agent representing Marshall, and we are both within the same office, We are now in designated agency within our office, and then another form will be sent out to both parties, informing them that the agents within this office working with them are designated agents, and we are now in full designated agency within our office. Okay? The designated agent for the buyer is R. We can put in Ron Carpenito, my name, right? I'm going to put in Prime Property Team, Ron Carpenito. Liriano Team, Steve Smith as buyer representatives, whoever the actual designated agent is that is representing the consumer, is their name is going to be put in here. Now, this gets a little bit challenging on teams, okay? If you're on a team and we're in designated agency, the best scenario is the team has buyer agents doing their thing and listing agents doing their thing. So example, the ABC team, Ron Carpenito is buyer agent. That doesn't mean the ABC team, Steve Smith on the listing side represents the buyer. Okay, just because they've hired the team doesn't mean everyone on the team is their agent, right? That's the best case scenario. Some teams might operate where they do buying and selling, and everyone on the team is going to be a buyer agent for this person. You'd put all their names in here, right? Confusion would happen, or dual agency would happen if the team gets a listing that the buyer wants to buy, because now the listings are being represented by the team and the same person has been written here as a buyer agent, right? That's called dual agency, which we're going to get into right now, consent to dual agency. The buyer agents the buyer understands that the designated buyer agent with whom the buyer is working also represents sellers, and that if the buyer is introduced to a property listed by that agent on behalf of a seller, a dual agency will be created. The designated buyer's agent may act as a dual agent who represents both prospective buyer and seller with their informed written consent. The dual agent is authorized to assist the buyer and seller in a transaction, but will remain neutral regarding any conflicting interest of the buyer or seller. Consequently, a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, reasonable care, and obedience to lawful instructions, but will still owe the duty of confidentiality of material information and the duty to account for funds, right? So dual agents, right? Confidentiality of motives, terms, and values, and accounting of funds, but they can't properly fulfill the full fiduciary duties as it may conflict with the interest of the other party. And that's what dual agency is, right? You become like Sweden. You're like Sweden, you're neutral, right? You can do dual agency in our office. I've done it, right? Dual agency is I have the listing and my buyer wants to buy it. My buyer client hired me, my seller hired me. I am now a dual agent, right? And my negotiating and advocacy role drops out because I can't advocate to the betterment of the buyer over the seller, or the betterment of the seller over the buyer. But the level of service has risen. There's one agent involved. The information flow is much greater. There's a trust factor that's higher because they hired me, they trust me. You hire me, you trust me, right? So there's a higher trust factor. It's the advocacy role that has dropped out. There's nothing dirty or illegal about it as long as it's done with informed consent by both parties. And you're getting that consent right here, okay? And the listing contract gets consent from the seller, okay? So that is one example of dual agency in our office, how it will work, all right? Where did I leave off now? Okay. Buyer understands that material information received from either client that is confidential may not be disclosed by a dual agent, except one, if the disclosure is expressly authorized. I authorize you to tell the other party this information. Okay. Two, if such disclosure is required by law. I must legally tell the other side this, Mr. Buyer. I'm sorry. Three, if such disclosure is intended to prevent illegal conduct. My mind doesn't go to those places, so I don't know what I would be having to disclose to prevent illegal conduct. Or four, if such disclosure is necessary to prosecute a claim against a person represented or to defend a claim against the broker or salesperson. So if we get to a legal matter, some type of lawsuit, and I need to defend and do things like that, then I'm going to start being able to disclose things, okay? This duty of confidentiality shall continue after termination of the broker relationship. When the agent with whom the buyer is working is a dual agent, that broker with whom the agent is affiliated is also a dual agent. Susan Roquarger is also a dual agent when I am the dual agent, right? And she shall remain neutral as to any conflicting interests of the buyer and seller. By signing this agreement, the buyer consents to have the designated agent act as a dual agent, except as expressly provided, the dual agent shall not extend to other licensees affiliated with the broker, meaning no other agent in this office would be in a dual agency capacity with the client. If dual agency occurs in a transaction, guess what? A notice of dual agency will be given. Just like if designated agency within the office is done, there'll be another form given out. Okay? Some heavy duty stuff there on agency. Questions, thoughts, comments?
That extra form.
Yeah.
of Dual agency,
Yes.
that will come, let's say, after office accepted or.
Excellent question. Excellent question. Excellent question. Now, I would say, I would send that notice of dual agency, after a showing has been conducted and the buyer has decided to buy my listing. Because now we're getting into offer writing and now we're in dual agency. I definitely represent the seller at the moment they want to write an offer. And I'm definitely representing the buyer at the moment they want to write an offer. So I'm actually in dual agency. Hyper technically, I am in dual agency, hyper technically, when they want to go see the property. Because I'm going to show my own listing to the buyer, right? So I'm in dual agency right from the beginning. So hyper technically, you probably should do the dual agency form right before you even show the property. But I'm just saying, it's a matter of practicality. Hey, Marshall, let's go look at the home. I'm their agent. I can't really give you much information. If you want to write an offer, we're going to have to get more formalized with the documentation of dual agency. You wouldn't be wrong to do the disclosure immediately. There wouldn't be a problem with that. It probably would be the much higher level agent to do it right up front. Hey, if you want to see this home, that's fantastic. I need to notify you, you'll be a dual agency as we agreed to in our agreement forms. I'm sending that off now. I'll set up the showing. Sure. That would definitely be let's just default to that. Send the dual agency form or the designated agency form before you even show the property. That would be high level.
This is consent to dual agency as well. You need an additional.
Well, this is consent. The buyer agency agreement is consent to dual and designated. But if you remember what we just read, it says an additional disclosure will be given if we find ourselves in that circumstance. Okay. Roger that. Disclosure of identity, other brokers, other potential buyers. The broker is authorized to disclose the buyer's identity. The broker is authorized to cooperate with and pay compensation to other brokers in connection with the performance of broker services. When does that come into play? Any idea? Could come in play during teams. You might hire Ron Carpenito as your buyer agent, but I've got Jody Smith as my showing specialist, and she's showing you the homes. I'm going to be compensating her for her actions, once you close, right? So you're authorizing me to pay her on your behalf, right? That's what that line is saying, basically. One example of what it could be, right? And guess what? The buyer understands that the broker may represent other buyers interested in purchasing the same or similar property, and the buyer consents to representation. That's a third time. Do you think it's important? It's very important to let the client know you have other clients. Entire agreement. This agreement is the entire agreement between the parties. It is binding upon the parties, heirs, successors, and personal representatives. Assignment shall not limit the right of broker. This agreement shall be governed by the laws of Massachusetts unless otherwise stated. The agreement may not be modified except in writing, signed by both parties. This is a bilateral agreement. The buyer doesn't have the right to cancel it. You actually don't have the right to cancel it. It has to be canceled by both parties unless there is additional provisions written in that give parties the right to cancel things. Okay? Now, one thing that we're going to write in other provisions that need to be in all buyer agency agreements, okay, is, and you want to write this down. One, I probably should have brought my written copy of this. I'm going to go off the top of my head. Basically, it says that broker is not required to seek out for sale by owner property, FSBO, and will do so at request of buyer in accordance with section 1 of this agreement. Okay, now what am I writing in there? It's pretty self-explanatory. Mr. Buyer, I can't be responsible to know of every single for sale by owner property out in the world today. There could be a guy out there, a gal, with a sign in their yard on a busy street that says for sale by owner, call me today. Okay? You're not gonna be aware of that unless it's in a Zillow, it's in an MLS with a co-broke or whatever, right? You're not gonna be aware of it, but they might be aware of it driving by. They need to let you know they saw that. You do not want to be responsible for seeking out property that you cannot readily find through your technology, okay? Why are we writing this in here? I'm too old now in this business, but maybe 10 years ago now, there was a lawsuit, again, this is why we're writing this in, where a buyer agent was showing property in a subdivision of like 200-300 homes, a big subdivision. And he helped a woman buy a home, and let's say it was $500,000, right? Lady moves in and she's talking to the neighbors, and the neighbor says, gee, I'm surprised you bought this home, because John's home, he was trying to sell that himself. It was like $50,000 cheaper because he had to, sell quickly. Couldn't hire an agent because he owed money, whatever, right? He's selling it on his own. No co-broke, nothing. Wasn't in any accessible database. He had to sign up, for sale. Somehow they missed it. Maybe the agent didn't want to show because there was no co-broke fee and he had no agreement to get paid. Okay. Maybe that's what happened. The lady sued the brokerage firm because the houses are in subdivision are very identical. So this would have been a property that he agreed, according to the contract, to show properties that meet their needs, right? Didn't show it. The judge found that he should have been able to readily know that was there because there was a sign, maybe a sign up. I don't know the full detail. I could find it out and send you the link to the case, but faulted the brokerage firm, fined the brokerage firm, the difference in the money, all that stuff. Because these contracts don't spell out where and how you're looking for property and what you're going to be looking for. It just says any property, right? So that's why we want you to write something that says, hey, I want to set the expectations, Marshall. I'm great. I am Superman, but I'm not going to be able to know every home for sale by everybody who's got a little sign out on the ground. Marshall, if you are driving by home from work one night, you see a sign out front, would you please call me? And in accordance with our agreement, I'd be happy to reach out to that seller. I'll get the information, set up a showing, find out more if it meets our needs, and we'll put a deal together if it makes sense for you. That's exactly what you say, right? And they're like, yeah, of course. No problem. But you're letting them know. You're not going to know about every for sale by owner that's out there. Okay. Let's see. The document creates a binding legal obligation for legal advice consultant attorney. You date it, you sign it as the representative, and then they sign it. Get them to initial the front page, bottom as well. Okay. That's the exclusive agency agreement, and that is the biggest part of this class. So now everything else is going to go much faster. So we will finish on time. You don't remember about? Okay, that's fine. The next form, pull up, is the wire fraud advisory form. Now, what is this form? I'm not going to read this whole form to you. We're just going to kind of broadly discuss it. It literally is a form where you're advising the buyer to never transmit any personal recognizable details over the internet, like a bank account information, birth date, social security numbers, things like that. It's warning them about the prevalence in our industry of wire fraud. And if you think about it, I don't want to get too deep into it. Our industry is so ripe for this. Why? Everything is public. Okay. When I list a home, my name is associated with that. My picture, my email, where I'm from, right? We know the seller's information because it's all public records, right? So it's super easy to affect the seller in this case, right? You know the seller's name, a Google search, you can find out their email address. You can create a Gmail account, Ron Carpenito, KW@gmail.com, something that might look like mine. You could put a signature field in by just scraping my face off the web. And, you might even have an email from me. You might sign up on my web hunter, get my email, you get my tagline, you get everything, and you just put it in your email. Now, if you're a scam artist, that Zillow says when it goes contingent under agreement, and you know that it's typically on average 30 days to a closing. So you as a scam artist know that the time to strike would be probably, 21 to 28 days. And then you find the seller's email address and you send an email to them, 10 o'clock at night. Hey, excited for the closing coming up, because it's under agreement. You're a scammer. You see it on Zillow, it's under agreement. We need your XYZ. It looks like it's coming from me. Right? So this never happened to me, thank God. But now it's required that we get the consumers on both buy side and sell side to sign this wire fraud advisory form. Okay? Shouldn't really be any questions on that. Pretty self-explanatory. The next form. Consent to electronic delivery of purchase or sale documents. What is this form? Well, we all know that electronic signatures and electronic emails and stuff can be considered legally binding now. It's legitimate, right? But we still want to get permission to use our dot loop system, our DocuSign system, our emails as binding, things like that, right? And so this form is what you use to get that permission, all right? It says, hey, I have read and understand this consent to electronic delivery of documents, and I consent to electronic delivery of documents. Addendum A, in accordance with my instructions below. Electronic delivery of a signed document shall have the same effect as a delivery of an original. Why is this important? It's super important. It's a 2-page document. Most people, they'll fluff over this. They don't think they'll sign it, no big deal. Well, you want to put in the date. You want to put in who is signing. You want to use what email address they want the documents to go to and what they want to use for e-signing. The biggest time this happens is the problem is with divorce situations. If you have a husband and wife that hate each other and they're getting divorced, you best damn sure get signatures from both of them that they are allowing electronic signatures, okay? Because, it wouldn't be much for the disgruntled wife to hack into the husband's thing, to sign on his name, and, things can happen. You don't want any problems. They signed here, they said, use this email address. They gave me permission to do this. It's binding. We want permission. We want to know that they understand stuff's going to happen electronically. Page 2 says the addendum A, check all documents authorized for electronic delivery. Just check one. All documents related to the sale of property. Don't waste time picking and choosing documents. All the documents.
Do you have them initial the second page too?
Yes. I have them, every page of every page is initial. Okay. Next. Now, this is the facts for consumers, all right? This is a requirement by state, okay? Whenever you work with a buyer, you must give them this package. It's as important as the lead paint disclosure for homes built before 1978, which I don't think I have lead paint here today, which I do want to go over. This form basically talks about the timing of a home inspection, about home inspection, selecting a home inspector, what to do during the inspection, filing a complaint. I don't review this with them in my buyer consultation. I say, hey, the state requires I give you this disclosure about home inspections. You'll have the choice of having, you have the right to inspections. In today's world, a lot of buyers are waiving inspections to get deals, under agreement. Doesn't mean we can't maybe have an inspection before an offer, a little dialogue around that. But, the state wants you to know that you are entitled, to have a home inspection. You should have one, right? We should always be advising they have a home inspection. Gray area, the world's a gray area. Ron, what do I need to do to get this property? Okay. How do you answer that? Hey, listen, the law says you're supposed to you should have a home inspection. You're entitled to a home inspection. It's your decision what you want to do with a home inspection. I can never advise that you do not get a home inspection. That's the words. I can never advise that you don't get a home inspection. Okay. Having said that, reading the scope, reading the landscape of what we see here, we do see a lot of people waiving home inspections. That's what's happening. What would you feel most comfortable doing? That's how you have to phrase it. That's how I would phrase it. You're not telling them to waive it. You're not telling them not to waive it. It's your decision, Amy. Here's what's happening. You want to go back in for a second look? You want to bring a contractor in? You want to bring my home inspectors on standby? I can get him in to do a once over with you, nothing in writing, but just do a walkthrough. Would you be comfortable with that? Ron, I really want to waive the home inspection, but I'm not so comfortable. Great. Well, then let's leave it in there and let's see how it goes. Let's offer them more money for the home inspection. Let's offer a, phrasing around it's going to be a informational only, or we agree to no further reductions. We agree to buy this property. We'll do the home inspection after the purchase and sales agreement. Amy, do you want the right to walk away from the transaction, or do you just want to have a home inspection? Oh, I'm buying the home no matter what. I just want to know what I'm getting into. Great. Let's put a home inspection in after the purchase and sales agreement, right? Our office, I don't have the paperwork with me today, but our office does have a new document that if they are waiving home inspection, they are signing a document that says they're waiving home inspection, okay? Because I'm telling you right now, I'm not privy to so much, super knowledge about lawsuits from our office, but I can imagine with the amount of volume our company does, somebody out there bought a home without a home inspection and is blaming one of our agents for waiving the home inspection, and now they've got $20,000 worth of work to do, and they want a pound of flesh from somebody because they can't, pay for it. So I think that's probably why that form came up, but I'm not saying it happened. I don't know. It could happen, right? So that's that form. And now you're going to get them to sign that home inspector form. So you don't just give them the form. I would have a second form and just have them initial it that you've got a copy, that they've initialed that they got a copy of it. Imagine, Kate, we didn't prepare I'm sure there's a sign off sheet that, that are in the loops to prove that they got a copy of this document, right? So that's the buyer side forms for today. Oh, I'm sorry. There is one more form. We've got plenty of time to do it. It's the updated agency form, right? Here's the updated agency form. No. Where did I put it? Over here. I'll still say 2017.
Right here, right here, Ron, right here.
Sorry, guys. Yeah, there it is. You guys have, here's a copy for you.
Yeah, I have.
She gave it to you guys?
Yeah,
Okay.
she gave it to us.
Okay, I'm gonna go over the new agency form. That one that just came out, that Shelley brought to our attention back in September. Thank you again, Shelley. I love this form. It's the best form, right? Commonwealth of Massachusetts Board of Registration of Real Estate Brokers and Salespersons website. Mass mandatory licensing consumer relationship disclosure. This is not a contract, right? This is not a contract. It's a disclosure form. I'm disclosing to you who I am. Am I here to assist you in buying a home and represent your best interests? Am I here as a wolf in sheep's clothing? I represent the seller and I'm trying to get you to pay top dollar on the seller's best terms, and close in 10 days, whatever. Or am I here as a facilitator? I'm a non-agent. I don't really represent, I'm not loyal to anyone in this transaction. We're having a conversation. You haven't hired me yet, type dialogue, right? Now, this disclosure is provided to you, the consumer, by the real estate licensee listed in this disclosure. The time when the licensee must provide this notice to the consumer. All real estate licensees must present this form to you at the first personal meeting with you to discuss a specific residential property. So I go on a listing appointment and I'm in someone's home and I'm meeting them for the first time. And we are there to discuss the market and the value of their home and what they need to do to their home to improve it to sell. Am I there to discuss a specific property?
Yes.
Great. When does this form have to come out? Right then and there at the first personal meeting. And I'm there to explain to them, I'm here as a seller's agent, maybe. I'm here as a buyer agent. I might actually have a buyer client for this home in my back pocket, right? They hired me to buy a home just like yours. I could potentially be in a dual agency situation right from the beginning. I could be there. I could be disclosing to them, hey, I'm here. How about this? You go see a for sale by owner. You go see a for sale by owner on behalf of your buyer client. At the first meeting with that consumer, you pull this form out and you let them know you are a buyer's agent. You're checking off buyer agent. Okay. You're representing a buyer there. When they sign below, they'll be signing as seller. Okay. See how clear that was? I disclosed to the seller of this home that I am here as a buyer agent. That's what this is for. Okay. Hi. Oh, you're so
wanna get
good.
Right now.
I love it. Ashley is the best. Make sure you let her know when you come in the office. Okay. So we can do some lead paint next. Okay. Back on this one. All licensees must present the form, the first personal meeting with you to discuss a specific residential property. If there is no personal meeting between you and the licensee, this form must be presented electronically or through some other means. Boom. To Shelley's point, that's the new change right there. Look at that. If there's no personal meeting between you and the licensee, this form must be presented electronically or through some other means before the licensee enters into a contract with a consumer. Is this a contract?
No.
No. The contract is the big form we just talked about. So when might this happen? I have clients that don't even live in the state of Massachusetts, but I need to have them sign a contract, right, to work with me. listing contract, for sure, right? This is just saying, you know, even if you don't meet them in person, right? Before they enter into an exclusive right to sell contract, an exclusive buyer agency contract, you got to make sure you get them a copy of this form. I can imagine that language was added in there because maybe there was some confusion. Maybe some agents never got this form signed when their clients were not local and they never saw them in person. And they defaulted to, well, I just said at the first personal meeting and I never met them personally, you know, so I just sent the contracts out electronically. And that's why that was probably added in. Okay. Residential property is defined as land with a building intended for use as a 1, 2, 4 unit residential dwelling, or the purchase or sale of land on which a building is intended to be constructed for use as a 1 or 2 unit residential dwelling. In the event this relationship changes, an additional disclosure must be provided and completed at that time. Okay. Now, I think another change I'm noticing is the use of the term residential property. Okay. I'm looking now at the older form and it doesn't mention residential property. Okay. So our commercial friends may be off the hook. And it further defines this as to what is a residential property in the eyes of the Commonwealth. Okay. It's defined as land with a building intended for use as a 1, 2, 4 unit residential dwelling, or the purchase of or sale of land on which a building is intended to be constructed for the use as a 1 or 2 unit residential dwelling. 1 or 2 unit residential dwelling. It's a little different. Interesting. Hey, you know what? Just default to getting it signed. Don't worry about the mishigash around what we're looking at. Just get it signed, right? Because you'll be safe to get it signed. All right. Consumer information and responsibility. If you are a buyer or seller, you can engage a licensee to provide advice, assistance, and representation to you as your agent. The licensee can represent you as the seller's agent or represent you as the buyer's agent or can assist you as a facilitator. All real estate licensees, regardless of the working relationship with a consumer, must by law present properties honestly and accurately and disclose known material defects in the real estate. We call that fair and honest business dealings. So I might represent a seller, right? And Chris comes into my open house. Hey, Ron, I want to write an offer on this home right now. I love it so bad. Great, Chris. I'm so happy for you. Chris, do you have a buyer agent? You working with an agent? No. I want to write it through you directly. Great. Okay, Chris. I'm whipping out the agency form. I'm having Chris sign it as seller. I'm the seller's agent. I'm disclosing to Chris that I'm the seller's agent. She is now an unrepresented seller. Chris, just want to let you know, law requires that I represent to you who I am at this moment. And right now I'm here at the open house. I'm the seller's agent. They've hired me to sell their home. So you need to know that I represent the seller in their best interests. You have a right in Massachusetts to representation. Would you like to get an agent? Do you need an agent? No, I don't want to risk it. Market's too hot. I want to write it right through you. I might have a better chance writing it through you. Okay, Chris, no problem. I still have a duty to have fair and honest business dealings with you and disclose any known material defects that I'm aware of in the property. Is that okay with you? Great. Okay, Chris, I'm the seller's agent. You sign here as buyer. Now you've been disclosed that I am the seller's agent. Simple as that. That's it. Now, when I work through that whole transaction, I am the seller's agent. I'm working with the consumer with fair and honest business dealings. But make no bones about it, I've disclosed to you my duty is to get the best price, terms, and conditions for the seller. That's my job. Okay? I'm not a dual agent. I didn't create a dual agency at an open house and just throw my seller under the bus who just hired me. No, I'm advocating for my client, the seller. I hope there's no confusion on that because a lot of agents have confusion around that. They think if they're hosting.
Agency, you have to like already have a relationship with both and it comes together. It can't be like just like someone comes to the open house and then all of a sudden I'm going to take you on also with the client.
So what you just described is the confusion that a lot of agents have. They think that I'm hosting an open house and a buyer has come forward and they want to buy the home. So I'm going to disclose that I'm the buyer agent because I'm working with the buyer. They don't understand. This form is to disclose to the consumer who you are at this moment in time in front of them. Can they trust you as a buyer agent? Should they know that you represent the seller or you are non-agent? That's all it is. I'm here as a seller's agent. You want to buy the home through me? You don't have an agent? I can't be your agent, I'm the seller's agent. But Ron, I want you to be my buyer agent. It's impossible, Amy. I'm the seller's agent. If I signed on as buyer agent, I would immediately create dual agency, which is basically dropping the advocacy role out and no further, right? Now, a clever buyer might say that and try to knock the agent's negotiating ability out, an advocacy role out. Well, I want you to sign up as buyer agent for me. And a student agent might say, sure. Here's another thing that agents get confused about. They think that if they sign buyer here, again, the scenario, I'm the seller's agent. You come in, you're a buyer. For me to keep the entire commission, I have to be working with the buyer as their agent to get the buy side. Some agents think that. No, that's not the case. You're the seller's agent. You agree to a fee of 6%, right? If there is a buyer agent present, you are going to give a portion of that fee to someone else. If there is no buyer agent present, this brokerage firm is keeping the whole 6%. That's all that it is. And you're going to get it all. That's fine. Okay. So don't be confused. The sellers hired you to sell a home. Okay. Do not create dual agency in an open house because a buyer wants to buy the home directly through you. Do not say, I'm afraid. I don't feel comfortable doing that. I don't feel comfortable working both sides. You're not working both sides. You work for the seller and you're helping a consumer with fair and honest business dealings buy your client's home. That's what you're doing.
I've heard several agents in the office say that they don't do not dual agency. They don't do that
Single
because
agency.
they feel that both parties should be represented.
Okay. All right. Let's talk about that. You could have a business practice, and as long as your seller is aware of it, Mr. Seller, if anyone comes directly to me to buy the home, you know, our value proposition in our team is that, you know, we represent each client at a high level, and we just, you know, don't feel it's high integrity to have an unrepresented buyer at the table. I'm spitballing right now, right? And so therefore, if an unrepresented buyer comes to your home, we'll have a buyer agent team member in the office handle that side of the transaction. So you can rest assured that I'm solely representing you in your best interest, and that this buyer has representation as well. So that actually could protect you, Mr. Seller, in the long run, because they have some, you know, representation. So that could be a business decision that you decide to do. Sure. Right. But it's definitely not, you're definitely not creating a dual agency in an open house you should not be creating a dual agency in an open house by signing buyer on the agency form. And now you go into dual agency immediately. Your seller will be like, what the hell? You're my agent. I hired you. They just came in. You just met this person at the open house and now they're your client. How can that be? All right. Let's move forward. We could talk more. I could talk all day long about dual agency and stuff like that if you want, but not today. Let's just go through this form. All right, here we go.
Hey, Ron, can you hear me?
Hi.
It's Jen.
Hi,
How are
Jen.
you?
Good. How are you?
I just thought, one other thing to point out with regard to that, though, is that the unrepresented buyer usually is thinking that they have a better chance because the seller is going to get to keep more money, not that the agent was going to get to keep more money.
Mhm.
So that
Possible.
definitely needs to be clarified.
Right. So again, I don't know, maybe there's many different ways to look at that. If the consumer asked me that question, if they said, hey, if I write the offer through you, does the seller get a better deal on their commission? Depending on what arrangement I have with my seller, that may be the case. And that would be called what, Jen? Do you remember?
What do you mean?
It's called a dual rate commission agreement, right? Dual rate, which
Oh, yeah,
means
the variable. Yeah.
not variable, dual
Yeah.
rate. Variable is different. Dual rate is when, hey, Mr. Seller, it's 6%, but if I sell it myself, I'll do it for 4%. That's a dual rate commission. So that's the case where a buyer comes in and says, I want to write it through you because I think the seller, if they say, I think the seller might have a better chance of whatever, make more money by accepting the offer directly through you. Fair and honest business dealings. I mean, it kind of rubs against contracts or confidentiality with your clients. I would tell the buyer, hey, you know, my fee arrangement with my client is really confidential and you're not my client and you're a consumer. Do you want to buy the home or not? Let's put your best offer forward. My fee arrangement is none of your damn business, pound sand. I wouldn't say that, but that's basically what I would say, Jen. What do you think, Jen?
Well, I just think that's why a lot of buyers are coming into open houses and thinking that the seller would like their offer more if they didn't have a buyer's agent. And that's not, it's not the truth. I mean, and it's also not the truth that those tend to be the most accepted offers, because you're
Correct.
now working with someone who's unrepresented, and very likely they're just gonna, be done with it after the first deposit.
Jen, I love you because you're reading my mind. I was thinking exactly the same thing. And you do listings too. We love buyer agents. We want a buyer agent on the other end of the side. For me, I want them there, because I have some level of hopefully expectation that the buyer's been vetted out, right, Jen? That they're not wasting their time working with some Stunaccia that can't buy a home, right, Jen?
Right.
And two, I really do just kind of want to represent my client and not, I mean, in a perfect world, I want to represent my client. And I like having that insulation of the buyer agent, because we could talk like professionals and work through challenges and problems and keep the parties at the table, right? Which is what we get paid to do. I love buyer agents on the other end of the equation. Okay. But Jen,
Especially in this market, because if you just got bid up, $50,000-$100,000, and then that person doesn't follow through, it goes back on the market at the low amount that got the multiple offers,
right.
and you just lost your client a lot of
Money,
Net.
time and effort. Right.
Mhm.
And I mean,
Yeah.
this just happened to me, like in the Salem Street home, Jen. I had the listing on, and a broker comes to me, wants to buy the home. He wants to buy the home himself. He's a real estate agent, right? And he wants to write the offer through me. I says, what do you mean? I said, you're a real estate agent, right? He's like, yeah, I know. I want to write it through you. You can keep the commission. I don't need a buyer agency fee. I'm like, you need that in writing from your broker. You don't make that decision. Your broker makes that decision. And I said, I'm like, okay. I'm like, I have to put I work for my client. What's in my client's best interest here? I need to get that offer in, I'm not going to say, no, I'm not going to write your offer. That would be a bad thing. So I'm like, okay, if this is how you want to proceed, come on in. So I wrote the offer. He's an agent, but not acting as his own agent. Because first I said, hey, you could just fill out your offer and send it in. You're an agent. Nope. Came into the office, spent countless hours with him. And just like Jen said, the next day, he himself backed out. I'm like, did you even vet yourself? I said to the guy, I'm like, what are you talking about? He showed me a pre-qualification letter, but then of course something happened within 24 hours. And, I am actually, I think jaded, or I don't want to say the word jaded, but just maybe experience, Jen. People coming directly to the listing agent, I don't think it works well. I feel like it's like Jen said, most of the time it doesn't pan out, or it's like they have they don't like working with agents in general, so they don't have a buyer agent, or maybe they're not qualified to buy, or maybe they're just not serious. People who are serious have an agent, typically. 98% of all deals are done through real estate agents. Okay, so that tells you something of someone not working with an agent, right, Jen?
I don't know if I'm still on. Oh, no, I'm not on mute. Yes, no, I 100% agree. I had that happen on the Linfield, on my listing in Linfield, where they had someone came, it was a builder's daughter, and it turns out she'd backed out of quite a few. When I talked to some of the other, agents that came to open houses, and when it was back on the market, they're like, we know exactly who did that because she's done it to other places.
Right. So as listing agents, we get, knowledgeable about these kind of scenarios. And doesn't mean we're not going to try to make it something work for our client that might work. But we talk a lot about setting expectations. I had the talk with my client on my Linfield, and I'm like, look, this feels a little sketch. This is not typical. Let's, take it gently, tread lightly, see if it works out. Set the expectation up with the client, because I have this knowledge of these kind of scenarios, and you all will get that knowledge as well the more deals you do. But yeah, thank you, Jen. Good insight.
You're welcome.
Okay,
Good class, Ron.
thank you, Jen. I appreciate that. All right, so here we go. Let's keep going. The duties of a real estate licensee do not really, we read that already, actually, do not relieve the consumer. I don't know if I read that. I'll reread it. The duties of a real estate licensee do not relieve the consumers of the responsibility to protect their own interests. If you need advice for legal, tax, insurance, or land survey matters, it's your responsibility to consult a professional in those areas. Real estate licensees do not and cannot perform home, lead, paint, insect inspections, nor do they perform septic system, wetlands, or environmental evaluations. Do not assume that a real estate licensee works solely for you unless you have an agreement for that relationship. Wow. It's like the fourth time we're hearing that today. For a more detailed definition and description about real estate relationships, see page 2. The seller or buyer receiving this disclosure is advised that the real estate licensee named below is working as a, check 1, seller's agent, buyer agent, facilitator. Now, and this is the buyer side class. I'm assuming you had a buyer consultation. You're getting your paperwork signed to go to work. So everything looks great. You're checking off buyer agent, right? That's the premise of this class, the buyer class, right? If seller or buyer's agent is checked above, the licensee must complete the following section, okay? You will never check non-designated agency. The left side will never be checked in this office, okay? But you will always check designated agency on the right side. Only the licensee named herein represents the buyer in this situation, and any other agents in this situation, any other agents affiliated with the firm or business listed below do not represent you and may represent another party in your real estate transaction. So only the licensee named herein represents the, right, buyer, because I'm going to be working with the buyer, right? Perfect. By signing below, I, the real estate licensee, acknowledge that this disclosure has been provided to the consumer named herein. You will sign there where it says signature of licensee. You'll print your name and put your license number there. Top agents will have this pre-populated with your name and your license number and stuff like that. So it looks professional, right? You will check off salesperson because you are a salesperson. You are not a broker, okay? I don't have the answer. It's probably a good question, but if I achieve my broker license, would I check off broker? I think I would say no, because my affiliation with this office is that salesperson, right? Susan is the broker of record. Even though I might have a broker license, I'm not the broker of the firm. I think that might cause confusion to the consumer. Jen, you have your hand up. Do you have your hand up? I see a hand wave.
It was up before. I need to learn how to take it down off my phone.
Gotcha. No worries. Thank you. Okay. Name of the real estate brokerage firm: Keller Williams Realty Success. Brokerage firm license number: 7874. 7674. No, what was it? 7874. Right off the top of my head. 7874. 7874. 7874. Signature of the consumer. Person who's signing it. Your new buyer client, right? Print their name, check off buyer, and put today's date. Now down the bottom, you'll see it says check here if the consumer declines to sign this notice. Now, why would the consumer decline to sign this notice? Why would the consumer decline to sign this notice? Well, in our example, you've had a consultation with them, they referred to you, they're not going to decline to sign this notice. That's going to be fine. True, or they're adverse to signing stuff. So when does this normally get, first of all, there's no normal. It's very rare that someone refuses to sign this, right? But when would it potentially happen? Okay. If you're an agent who is maybe, responding in an emergency fashion to someone who wants to see a home that you've never met, and you go to their house, go to the house to show it, right? And you are the listing agent, right? And you need to, wait a minute, let me backtrack. If I'm the listing agent and a consumer calls me to see the home, that's not really an emergency situation. It's my home to show. They're probably coming to the office. We'll have a dialogue about the home, and I'll present this form saying I'm the seller's agent, and they need to sign it. They may not want to sign it, right? Because they might say, I'm not signing anything. I'm just here to look at a home, right? They'll, okay, Mr. Consumer, would you mind checking here and initialing here, right? That's what I would do. I would ask them to do that, right? If they do that, I've in essence gotten them to at least initial the form, right? Which is great. A super smart consumer might say, I'm not checking or initialing anything. I'm not signing anything. Then you check off there and you sign there. Consumer just declined to initial this form. You would then ask the consumer for an email address, which you probably already have because they probably contacted you through the internet, right? And then you say, no problem, I'll send you a copy of this form or something. Now you'll have a email trail that you have at least sent them something, right? Because if they're not going to sign it, you can't prove that you gave it to them, which you need to, right? So the other time that comes up is, let's say a lot of buyer agents will buy leads. They'll buy buyer leads, right? So, Amy, you're sitting home and the ding, 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 Red Zill Realtor lead, whatever it's called, right? Will come through and, Marshall wants to see a home at 3 o'clock today. And you're like, hey, a showing. And you're going to set up a showing and you go there. Now, you're not the listing agent and you're not a buyer agent yet. You haven't been hired by them. You're not, yet. What are you? You could be a facilitator. You could be showing the home as a facilitator, right? You could be showing the home as a buyer agent. You could immediately give them the obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care duties right at that first meeting without even knowing them, right? Create an agency with them by saying, I'm here representing you, right? I would advise showing it as a facilitator until you decide maybe they want to write an offer. Then you want to get stepped up to a buyer agent, things like that. I'm big on not creating agency relationships until the time comes to get hired or they're going to work with me, right? I don't want to give the illusion that I promised fiduciary duties to you. I explained to you that I'm your agent and then you go bye-bye. And then you might be able to come back and say, that guy was my agent. It said right here, he was my buyer agent, right? Okay, confusion. No, if you don't have a relationship with someone or you don't intend to see them past this moment or you don't know, you can start off as a facilitator. Start off as a facilitator and move towards buyer agency. Okay, there's a difference. Okay, next page. Let's go over some of these things real quickly. And then we will breeze through the lead paint form real quick. Type of representation, seller agent. We're not doing that today. We're doing that tomorrow. Buyer agent. We're doing that today. A buyer can engage the services of a licensee as the buyer agent purchasing the property. This means that the real estate agent represents the buyer who is a client. The agent owes the buyer client undivided loyalty, reasonable care, disclosure, obedience to lawful instruction, confidentiality, and accounting. The agent must put the buyer's interests first and attempt to negotiate price and terms acceptable to the buyer client. Now, in the market we live in, acceptable to the buyer client might mean 50,000 over asking price. When you read the words acceptable to the buyer client, do not mentally in your brain think the cheapest price or the lower price or less than asking price, or that is all arbitrary for the market you're in and for what the buyer's intention is to accomplish in the marketplace you're in. Acceptable to the buyer is what they're willing to sign the offer form on, because they shouldn't be signing the offer form if it's not acceptable to them. All right. And you shouldn't be submitting an offer, by the way, for anyone if they're not confident moving forward with that offer. You're never pushing someone to do something they don't want to do. Never. Okay. If they're not comfortable, they're not comfortable. Don't move forward. Okay. The buyer may also authorize subagents to represent him and her in the purchasing of a property. However, the buyer should be aware that wrongful action by the real estate agent or subagent may subject the buyer to legal liability for those wrongful actions. I don't really go into too much. First of all, I'm not reading page 2 in its entirety to these people, but we do talk about buyer's agency at a bigger level of obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. I don't get into the whole thing about authorizing sub-agents to represent them in the property and things like that. We could talk about that in detail later. Non-agent facilitator. When a real estate licensee works as a facilitator, the licensee assists the seller and or the buyer in reaching an agreement, but does not represent either the seller or the buyer in the transaction. It's a safer way of practicing real estate. A lot of states don't practice buyer agency like we do. We're a unique state, okay? If you go to Florida, they have buyer agency, but no one practices it. Very few. It's more transactionary, or what we call facilitation. So my partner, Arlene Santangelo, she works down in the Bonita Springs office. When she works with the buyer, it's as a transaction agent. She's not representing anyone legally. She's working for the transaction, for the deal, bringing the buyer and seller together. She's not although she might do some advocacy because she can't help it, but she's, not a buyer agent. So other states don't even have agency. They have transactionary brokerage stuff. So this is why when you're on Facebook and you're seeing questions from groups on things, right? If you're going to offer an answer, indicate what state you're in. Indicate, well, I'm in Massachusetts and here's how we handle it here. Because agencies and relationships are different in different states. And also when you read an answer for someone and you say, oh, that sounds great, I'm going to do that. Check with your board, check with your broker. It may not even be legal in our state. It may not even be how we do business in our state. So every state runs a little differently. Back to facilitation. The facilitator and the broker with whom the facilitator is affiliated owe the seller and the buyer a duty to present real property honestly and fairly and accurately by disclosing the material defects of the property, and owe a duty to account for funds. So it's disclosure and accounting. Duh. Facilitation is duh. So we're talking about old car. Facilitation, duh. Disclosure and accounting. That's it. No obedience, no loyalty, no confidentiality. Ooh, no confidentiality. Interesting, right? Okay. Unless otherwise agreed, the facilitator has no duty to keep information received from a seller or buyer confidential. Should the seller and or buyer expressly agree, a facilitator agreement can be changed to a seller or buyer client relationship with a written agreement. So that's a good one. So, oh, we don't really want to hire you as our agent yet. Oh, okay, great. You're just getting your feet wet. No problem. I can work with you as a facilitator. What's that? Well, I can help you facilitate stuff and, paperwork, and I could open a door and show you a home here and there, but I'm not your agent. You haven't hired me for fiduciaries, and I'm not going to really negotiate for you and those kind of things. And if we get comfortable with each other, we can step it up to the full level of service, right? See how you can now talk about your levels of service, right? Bronze, silver, gold levels of service, things like that, right? What else do I want to say about that? Oh, you cannot step down. You cannot go from a buyer agent to a facilitator. Once an agency relationship is created, it cannot be stepped back down. So once the bell has been rung, you cannot unring the bell. Okay. So, and by the way, you can also create an agency without any paperwork by simply acting as an agent. If you start acting as an agent, when I say agent, I mean with an agency relationship, you're creating an agency. So don't be offering advice and consultation and negotiating thoughts. I guarantee you, you do this long enough, someone's going to be trying to buy a home and they're going to call you up. What do you think we should do? What do you think? Blah, blah, blah. And I'll be like, you should have hired me, right? Like what? And now you're calling me. Well, our agent doesn't know what they're doing and we feel like this. And you'll get these calls.
I have.
Do not get involved. You got to talk to your agent. You got to talk to your agent. I'm not your agent. You start offering advice. Now you're actually creating an agency. There's a word for it that slips my mind right now. If anyone remembers it on the Zoom, let me know. But don't create an agency by action. Okay. Don't. Okay. Next section talks about designated sellers and buyer's agent, which we've already gone over designated agency. This is talking about how our office runs as a designated office for seller and buyer. And it also talks about dual agent, right? Which we're not going to talk about again because we just talked about it ad infinitum. Okay, good. That's the agency form. Questions on that? Anybody? Good. Lead paint. Lead paint, and then I will release you. I'm going to rip off the lead paint form in the back. Did you guys get copies of this? No. Now, we're not going to read through the 11 pages of the lead paint form. That's not what we're going to do today. Definitely not doing that. Okay. But this is probably the most important form that you'll need to deal with, okay, in my opinion. Commonwealth of Massachusetts, right here, wants you to give this packet to any buyer who is interested in buying a home built before 1978, okay? It explains their duties and requirements as a buyer as to what they must do if they buy a home built before 1978. And if they're going to have children residing in the home or be born in, pregnant women, they're going to do, extended amounts of time with kids in the home under age 6. Okay.
This is provided by the seller, right?
Okay. Good question, Marshall. As a buyer agent, you're never having your buyer sign a blank form. Never. Never. I have gotten many agents sending me over a pre-signed buyer side signing it. They don't even know what they're signing because the seller needs to disclose to the buyer what they know or don't know about lead paint. And then the buyer acknowledges what they've received, okay, or not received, okay? So never as a buyer agent are you taking a blank form and having your buyer fill out the buy side and sending it to a listing agent. You are always going to MLS paperclip. Hopefully the listing agent put it up there for you to download the seller disclosed side, and you're having your buyer sign that one, okay? If it's not there, guess what? You have to pick up the phone and call the agent hey, I'm gonna write an offer on this home. I want to make sure that we keep both of our clients protected, and that we know what we're getting into before we write the offer. Would you mind sending me over the property transfer notification certification form, also known as the lead paint form, right? Oh, yeah, I got that. Yeah, I haven't put my admin, didn't put it up yet. I'll send it over to you. Just send the offer first. Oh, okay. Crazy hot market. What are you gonna do? Listing agent's telling you to do something. You want to get off the right foot. It's complicated, right? It's confusing. What are you supposed to do? Well, the law says they need to have this form disclosed to them. All right. But when? Let's read. This form is to be signed by a buyer before signing a purchase and sale agreement or a memorandum of agreement, or by the leasee prospective purchaser before signing a lease with an option to purchase for property built before 78 for compliance with federal and mass lead-based paint disclosure requirements. Now, would a reasonable person assume or default to agree that the offer to purchase would be considered a memorandum or agreement? Yes. So before you write an offer form, this form must be signed. To me, it's black and white. Okay. Some people will hang their hat on, well, it says purchase and sales agreement, and that comes after the offer. So we can do the offer before the, okay, you want to hang your hat on that? Hang your hat on that. But I like the one that says memorandum of agreement, right? Which I believe to be the offer form. Okay. I believe they wrote all this stuff in here to be like a catch-all for all types of documents that are used to buy property, right? Because in New Hampshire, you got only a purchase and sales agreement. You don't have an offer form, right? Okay. So do your best to get it before the offer form. I have written offers though. I'll be honest with you. I've written offers without having this signed. But what do? In the additional terms, I say, subject to receipt of a property transfer notification form signed by buyer and seller prior to, either acceptance or prior to a home inspection beginning, something like, we want to see this before we really bind this deal. This deal is subject to that form coming over. Because your client, now, is that going to jeopardize the deal? Am I telling my client I'm putting that in there to cover their ass? I am, clearly. There will be mentors and teachers that'll tell you that, if this form is not available, they refuse to give you a form, that you should walk away. You should walk away from the property. You should not write an offer. Your license is more important than a deal. There are fines on this for not getting this done right. And if a kid gets sick, and it got found out that you didn't do this right, you're really in a lot of trouble. And it's not worth it. And you will have sleepless nights. I've had many, if you care, you will have sleepless nights if you don't get this form signed right. Okay. I take that back. I'm sure you all care. That was crude and rude. I'm sorry. I know how I feel. And if I don't get this form signed right, I don't sleep at night. Okay. And that's just how I am. All right, here we go. Required federal lead warning statement. Every purchaser of any interest in residential property on which a residential dwelling was built prior to 1978 is notified that such property may present exposure to lead from lead-based paint that may place young children at risk of developing lead poisoning. Lead poisoning in young children may produce permanent neurological brain damage, including learning disabilities, reduced intelligence quotients, behavioral problems, and impaired memory. Lead poisoning poses a particular risk to pregnant women. The seller of any interest in residential real property is required to provide the buyer with any information on lead-based paint hazards from risk assessments or inspections in the seller's possession, and notify the buyer of any known lead-based paint hazards. A risk assessment or inspection for possible lead-based paint hazards is recommended prior to purchase. Okay. Seller's disclosure. We're going to cover that tomorrow. Okay. What's going to go on there? So don't worry about that. But in the buy side class, you're going to have the purchaser initial C, D, E, or F here. Now, it's D, E, F most of the time. And why? Because typically this form comes to you this form comes to you and it's indicating unknown. I know Jen will probably confirm with me 95% of the time, this form is going to come from the seller side as unknown, no forms, nothing available. Right, Jen?
Yes. Oh, sorry. I didn't know I was still on mute as I was
You're
going
still
through
on.
things.
95% of the time, we receive these from listing agents with unknown, no knowledge. So the proper initialing of the buyer is D, E, and F when it's unknown. Okay? Why? Well, they have received no documents. Okay? I don't care that the seller had no documents, they have received no documents. So they had no documents because the seller had no documents, but they just did not receive any documents. So they're initialing D. E, the purchaser has received the property transfer lead paint notification. That is this form and this 10-page booklet. Okay? F, the purchaser or lessee has, check 1 or 2 below. 1, received a 10-day opportunity or a mutually agreed upon period to conduct a risk assessment or inspection for the premise of lead-based paint. Or 2, has waived the opportunity to conduct a risk assessment or inspection for the presence of lead-based paint. Okay, so you're initialing DEF, okay, and you're checking 1 or 2. Okay. Now, unless the client is expressly waiving their lead paint inspection, you're always checking I. Okay, or they are always checking I. Okay. Now, let's take it from the mindset that the seller does have some reports. Doesn't matter what the reports are. They might have reports. Okay. Now you're going to initial C, E, and F if you will receive the reports. If you receive the reports, okay. If you haven't received the reports, it's D, E, and F. Okay. Am I being clear? Listing agent says, oh, the home is free of lead paint. There was lead paint. The seller has all these forms, blah, blah, blah. Hey, great. Can I have the forms? No, we'll get them to you by next week before the home inspection. Okay. I'm checking off D, E, and F. I haven't received any forms yet at the signing of this document, right? Okay. Or, Ron, I'm sending over the lead paint. We had a lead paint test done when we bought this home. The seller is sending it over. Here it is. Yeah, we've received it, right? C, E, and F, right? Okay. Agent's acknowledgement. You are the buyer agent. You will be initialing H. What does H say? This is the best thing. You need to read this and do it. Agent has verbally, not email, not sent them a pre-made video that I sent to everybody, not, put the paperwork in front of them and told them to go home and read it. It's you have verbally informed the purchaser or the leasee purchaser of the possible presence of dangerous levels of lead in paint, plaster, putty, or other structural materials, and his or her obligations, the buyer, to bring a property into compliance with lead law, either through full deletting or interim control, if it was built before 78, and a child under 6 will reside in the property. Mr. Buyer, you're buying this home. I'm excited. We finally found the one. I have to verbally inform you, though, that if you're going to have a baby here, or you're bringing in kids under 6 that are going to reside in the home, basically full-time, the Massachusetts requires that you, the buyer, bring this home into lead paint compliance for safety for those kids within 90 days of taking ownership of this home. Read this document tonight. Okay? Read this document tonight. Tell you all about your requirements. Okay? And the damage that lead paint can cause. Okay? Now, I've already given this form to my client at the getting hired meeting. Okay? When I get hired, I actually go through all this stuff. That's why sometimes my appointments take longer. I'm doing it all up front, so that there's not going to be more hiccups and confusions, down the road. And we can think about it objectively. You want to talk about this before you're writing an offer on a property. Why? Because there's a pressure to buy this house, okay? This pressure. Decisions get altered under pressure, okay? Emotions are churning. I need a house. I got to buy a house, blah, blah. I don't care. I don't give a shit about lead paint. That happens, okay? However, before the property is identified, you should be having a discussion with your client about the dangers of lead paint. Do you really want to buy a home built before 78, Marshall? You got 2 twins at 3 years old. What do you think about it? When we talk about protecting, this is something you can do to protect people. Okay, you could talk about lead paint before they have to write an offer, before their emotions are up, and they don't want to think about lead paint, right? Let them think about it objectively before the house comes out. And of course, you're going to bring it up again, but at least They went forward looking at homes built before 78, knowing what they were getting into. Okay? And we could talk more about lead paint at another time. Anyone can call me about that if they want. Okay. Certificate, so you initial H after you've had the verbal discussion with them. The following parties have reviewed the information above and certified to the best of their knowledge, the information they have provided is true and accurate. The purchaser will sign where it says purchaser, and you will sign one of the agent lines that are available to you, because the other line should be signed by the seller's agent. And the address of the property will be in there. Okay, any questions on the lead paint certification? And again, you're only getting this form signed, you know, when it's been given to you by the seller's agent on the property you're about to write an offer on.
Information part you get to correct.
So you would be in compliance with the law. Compliance with the law would be, at the time of writing an offer, they see this from the seller, and you've handed them this form. That's compliance with the law. Taking it a level higher, in my book, is at the first personal meeting, or you're in your consultation, and you're giving them knowledge and information. You want to bring this up and say, Marshall, I don't want to spring this on you when you're trying to buy the home that you finally want to buy. I want you to review this with whoever you want to review it with, and just understand that lead paint's a problem for kids. You should read this over and think clearly now before a house presents itself, whether or not you want to get into this or how you want to handle this when it comes up. You know, you're going to want to get a lead paint test done, maybe. You know, maybe you don't care, but I just want to make sure you know about it, right? So I'm giving it to you now, right? And you know what? You can give it to them again if you want. Just keep giving it to them. Can't go wrong by giving it to them more. I don't know, maybe I'm just different. I had many sleepless nights about this. You know, I have had many sleepless nights, not anymore now. Back when I was younger though, I'd have many sleepless nights about this.
Yeah, you must not do rentals or you'd still be stressed.
My God, yeah, no rentals. Prime property team does not do rentals, but someone in our office we can connect you up with to help. Okay, so that's the buyer forms today that we're gonna cover. Covered a lot of stuff today. Thankfully, there won't be a test, but you should be taking these forms, internalizing them, reading through them, practicing how you're going to present them so that you don't practice in front of your client, right? Right. And if you ever want to practice in front of me or you want to talk to me about it, just call me. Okay? I'll see you tomorrow.
Thank you.
I hope at 11
Very
o'clock.
much. Yes.
So we ran 15 minutes late. I'm sorry.